Yes. So mention number item number 47 and 48 notice hearing authorization. So say conducting counsel Mr. S. Kotagi today some partial difficulty. Conducting counsel Mr. S. Kotagi today some partial difficulty. Matter will be taken up after 2 weeks notice. Any day.
Okay, Mr. B. Deori, the learned counsel appearing for the petitioner submits that the conducting counsel, Mr. S. Kotaki, is having some personal difficulties and prays for adjournment of the matter for 2 weeks. Prayer is allowed. Let the matter be listed after 2 weeks. You have to intervene the other side or
Not
the
if only-
state.
Devote.
I beg to mention item 19 also. I have taken from the other side.
Item 19.
In this case, I am appealing for a respondent, so we have some time to file our affidavit.
You are appealing for whom?
For respondent number 6,
Huh?
7 and 8 on behalf of the AGSO.
Your lordship, a date may be fixed, your lordship.
Mr. A. Chetri, the learned counsel, appearing on behalf of Mr. A.G. Sharma, the counsel, the learned counsel appearing for 7 and 8, prays for adjournment of the matter, which is not objected by the counsel appearing for the petitioner. Full stop. Did the matter be listed?
Your lordship, can be fixed on 11th of August. 11th of August.
Why so late?
Your lordship, my senior will be out of station.
Hmm?
My senior will be out of station, your lordship.
Mr. PK Kulda is out of the weeks.
Out of station for 2-3 months.
Yes, your lordship, for medical purpose.
Okay. Let the matter be fixed on 11th
11th
August.
of August.
11th. 11th August. Okay.
Obliges.
Lordship, beg to mention item number 29.
Item number?
29.
Yes.
I am appearing on behalf of L.M. Rahman. He is out of station today. Matter may be taken some other day.
But there are other councils are there.
I have taken consent.
No. There are so many councils are there only because Mr. L.R. Rahman is LM Rahman is not there. Why are you taking adjournment?
Actually,
There are so many. ISCK is there.
ISCK is also not.
Hmm?
So after
Okay. What is your name?
Amal Pathak, A Pathak.
Mr. A. Pathak, the learned counsel, appearing on behalf of Mr. L.M. Rahman, the learned conducting counsel, prays for adjournment of the matter. He submits that he has already taken the consent of the counsel appearing for the other side. Let the matter be listed after 3 weeks. After 3 weeks, yes.
May it please your lordship. Lordship, I beg to mention item number 4, my lord. My lord, in this case, my lord, respondent number 6 has died, my lord. My lord, we want a week's time to file a substitution, my lord.
The last time also you took time?
Yes, my lord, but we are not in contact with our client, my lord.
Okay, you are Mr. B.
Yes, Upadhyay, my lord.
S. Upadhyay, the learned counsel, appearing for the petitioner, submits that he requires some time to file a substitution petition in the instant case. Full stop. Prayer is allowed. Let the matter be listed after 3 weeks.
I am deeply obliged, my lord.
May I please, Lordship? I beg to mention item number 46, Lordship, and for the petitioner, Lordship may be taken after 2 weeks, Lordship.
Hmm?
After 2 weeks, Lordship.
46.
46.
46 has come for orders. Why? Why it has come for orders?
Lordship, we have taken stage for respondent number 5 and 8, Lordship.
Hmm.
And the service is not yet complete, Lordship.
Okay, on the prayer of the learned counsel appearing for the petitioner, let the matter be listed after 2 weeks. 2 weeks.
Obliged.
May it please, lordship.
Yes.
Lordship, I beg to mention our WPC.
Hmm?
Our WPC 6477 of 2022. Lordship, it was disposed on 26th May 2026. Lordship, it was mentioned along with WPC 4519 of 2025. Lordship, in bottom address, withdrawal was prayed for with a liberty to file again. But in bottom address, I have prayed for to file liberty.
It is already disposed of.
Yes, Lordship. However, in the WPC 6477/2022, in the order, the liberty part.
So it is disposed of. If disposed of, then how it will be listed?
Lordship, I prayed for to file again with liberty. So Lordship in 6477/2022.
You're filing a fresh petition.
Yes, Lordship.
So you go to the senior bench. You
But
have
it
to-
was,
You have to mention before the senior bench or any kind of new listing.
Lordship, actually, there was some mistake committed where like the order copy did not reflect that the liberty was given to file again, Your Lordship.
The liberty was not given probably.
Your Lordship.
How do you know that liberty was given?
Lordship, both the matters together was withdrawal was sought, and only on one matter the liberty was given, Your Lordship. Whereas in both
We
the
don't know. We don't know. You mentioned it before the senior bench. Mention it before the senior bench.
Lordship. Right.
And your Lordship, I beg to mention for listing on WPC relating to fishery settlement, Lordship.
Hmm.
Kindly.
Listing, you go to the senior bench. এটা বেইলি হিয়াৰিং আছিল যে সেইটো কিন্তু এতিয়া মানুহ নাই নেকি এইটো অলপ পিছত অলপমান পিছত
In this case, the record was called for Lordship, but we have not received. Today morning, I called the chairperson of the Nalbari Municipal Lordship. She will verify. According to her, she has sent, but our office has not received Lordship.
Hmm?
The record was called for,
Yes, it was recalled for a long time back.
but we have not received Lordship. Initially, some other advocates were appeared for that Nalbari Municipal Board Lordship.
Last time you have been
yes.
given time,
Yes,
3
yes.
weeks.
I have made communication Lordship. Today morning also I called the chairperson Lordship, and she will verify and inform me. But our office has not received any record.
Hmm?
Our office has not received any record. According to her, she instructed the office to send the record Lordship, but we have not received.
The 2 orders, passed
Yes, yes,
after that.
yes.
So where is the record now?
It is in Nalbari Municipal Board.
Nalbari municipality, nobody is appearing now.
No.
Hmm?
Okay.
Earlier appeared, but after some time, he
Stopped appearing.
withdrew from the
The
proceeding.
court instructed us to take the instruction Lordship. We have made communication Lordship, but even last month.
Okay, we'll give them some time then.
Yes.
Heard Mr. D. Chaudhary, the Learned Counsel for the petitioner, also heard Mr. N. Goswami, the Learned State Counsel for respondent numbers 2, 3, and 4. Mr. Goswami submits that Mr. Goswami prays for some more time to produce the record in the instant case. Produce the record from Nalbari Municipal Corporation.
Municipal
what?
board.
Municipal Board. Nalbari Municipal Board. Full stop. Let the matter be listed after 3 weeks.
Date may fix.
3 weeks at a date. That date after 3 weeks.
27.
Much. so.
Item 2.
Please, Your Lordship.
In this case, affidavit has been prepared.
Hmm.
Only due to the yesterday's holiday, the manager has not come down. So your lordship, just 2 or 3 days, then it will be fine.
The man appeared for the petitioner when the matter was called for. Mr. M. Sharma, the Learned Counsel, appearing for respondent number 2, 3, and 4, submits that the affidavit is already ready and he requires a week's time to file the same. Let the matter be listed after 2 weeks. MS so-and-so is present for respondent number 5. You just give your names, huh? Respondent number.
Item 3.
Wait, Mr. Lordship. Lordship, government and respondent number 6 are supposed to file affidavit in
Hmm?
opposition. Government and respondent number 6, last provision pays for time to file affidavit in opposition. Lordship, I'm appearing for respondent number 6. We won't be filing any affidavit. Order dated 22/4/26 may be paid in full.
Mr. Talukdar, you're filing something?
We have, there are some. Lordship will file. There are some instructions.
Okay, heard MS so the learned counsel appearing for the petitioner. Also heard Mr. BJ Talukdar, learned senior counsel assisted by Mr. PK Medi, learned counsel appearing for the state respondents. Also, Mr. Talukdar praised for, Mr. Talukdar submits that he has received some instructions and requires 2 weeks time to file the affidavit in opposition in the incident case. Let the matter be listed after 2 weeks. But 3 weeks, okay.
Date may be fixed. Ma'am.
After 3 weeks.
Okay.
File. May I please, your lordship? Your lordship, I have been newly engaged in the matter. My name is not reflected on Wakalatnama as of now. We will be filing the Wakalatnama by today or by Monday.
What is your name?
SS Talukdar, your
SS Talukdar.
short date may be given you.
Heard Mr. SS Talukdar, the learned counsel, appearing for the petitioners. He submits that he has been newly engaged in the matter and shall be filing his wakalatnama within a couple of days. Full stop. He prays for some accommodation. His prayer is not objected by the learned counsel appearing for Mr. R.K. Talukdar, learned standing counsel for power grid. For power grid for respondent numbers 1, 2, and 3. 1, 2, and 3. Has not opposed the prayer. Let the matter be listed after 2 weeks.
Please.
2 weeks.
6 to 15. If your honor, date may be given.
See, after 2 weeks, you file your wakalatnama first.
Lordship, it's a serious case
Hmm.
and we have been directed to file our affidavit in opposition. If failed, Lordship, the personal appearance will be there. We are going to file, it was fixed yesterday, but because of the holiday, Lordship, the case is listed today. And we are going to file it today, but one problem is, Lordship, that we have served copy upon the revenue as well as the petitioner. But today is online, most probably Harish Gupta, he is also a party to the. Asani, Asa. Lordship, I will serve a copy and file this today itself.
Today you are filing it.
Yes, yes.
Okay. Okay, none appeared for the petitioners when the matter was called for. However, Mr. H. Sharma, the London additional senior government advocate, is present for the state respondent. Mr. H. Sharma submits that affidavits in the instant in the instant case,
We are going
as
to
well as in all the matters.
No, in one case, Lordship, that will cover.
Okay, affidavit in the instant case has already been prepared and the same will be filed during the course of the day.
Lordship.
During the course of the day, full stop. In view of the aforesaid, let the matter be listed after 2 weeks. After 2 weeks, all the matters that all connected matters.
Not so bad.
Please, your lordship. Lordship, as per the last order, 21/5, the government was supposed to obtain some instructions, lordship.
Lordship, last.
It is small order why instruction was
We
required.
have filed our affidavit. My knowledge of it will cover everything, Lordship. In our original.
No, your affidavit is not sufficient. That's why instructions was called for. Your affidavit was not sufficient, Mr. Goswami.
Reflect, Lordship. I take the last order.
What does the brother reflect? And does the learned counsel respond number 2, he requires some time to complete his instructions in the matter. What does it say?
Otherwise, in our affidavit, Lordship.
In your affidavit, it was not covered. That's why an additional instruction was called for. You have not appeared in the matter earlier.
No, Lordship.
Mr. Endas was appearing, probably.
Lordship, I know, Lordship.
Correct. So there was one query was raised. If it is in eco-sensitive zone also, whether it can be converted to commercial land or not, provided
they follow the rules and regulations and then do not, because the objection was initially about setting up a petrol pump. If petrol pump they do not set up, they do some other activities, whether it can be commercialized or no commercialized or not. That was the issue, or that was a specific query court has asked, and he was saying that it will be covered. It will not cover. So we have asked for that specific query, that whether if they say that like we are not going to say, I mean, set up any petrol pump there, then what happens? Whether you can give him or not, then whether this agricultural land can be converted to commercial land or not. That was the query. That is what.
That is, some part of land has been already acquired, Lordship. Some portion of land has been acquired by the NHS itself. It is not.
Acquired. It is not for acquisition.
No. In the meantime, his some portion of land is acquired.
Some portion of land.
Yes.
There is nothing has come from the petitioner about this. You please take instructions. There was an order there. I mean, it has been, how many times we have given them time? You just see. You said that like order doesn't reflect so. You see how many times we have taken time. Or this simple this thing. You were also there in January, month of January. And what are you doing till that time, till this time? In January 22/1/2026, you took time. You have taken time, Mr. Goswami, in January. For this specific purpose, some instructions were required. And I mean, only because of the instruction the matter is pending.
I'll take it.
It cannot go on and go on like this. I mean, like small issues, I don't take instructions. Heard Mr.
B Hazard.
B. Hazarika, the learned counsel appearing for the petitioner, also heard Mr. N. Goswami, the learned counsel appearing for respondent numbers 2 and 3. Mr. N. Goswami submits that though effort has been made, he is yet to receive the instruction that has been sought for by this court in the instant case, full stop. He prays for 2 weeks' time to complete his instructions and intimate the court about the issue involved, full stop. Let the matter be listed after 2 weeks.
17.
Your Lordship, Senior Counsel Mr. P.K. Kolta is on legs on court number 3, Your Lordship. Maybe pass over for the time being.
Mr. Sharma is there, Sharma, affidavit.
I talked to Mr. H. Kamal Lordship. He has not received any instruction.
Respondent number 4 has filed affidavit, Your Lordship.
Respondent number 4 has filed affidavit long time back,
Yes,
in
Your Lordship, it is
2024.
vague.
That's sufficient.
But they wanted some time to file affidavit, but you are not filing the affidavit. We'll give them some time.
Yes, Your Lordship.
Okay.
Can be fixed on the same date, Your Lordship, 11th of August.
The same date, I don't know. I mean, heard Mr.
K. Talukdar.
K. Talukdar, the learned counsel appearing for the petitioner, also heard Mr. N. Goswami, the learned government advocate for respondent number 3 and 4.
Okay.
Respondent number 3 and 4. Mr. Goswami submits that he is yet to receive the instructions to file affidavit in the instant case and prays for 2 weeks' time. This prayer is allowed. Let the matter be listed up. Let the matter be listed after. Let the matter be listed and as prayed for by the learned counsel appearing for the petitioner. Let the matter be listed on 11th August. Okay.
Pursuant to the last order, I filed my rejoinder to the counter affidavit filed by the respondent number 2. I have filed my rejoinder affidavit on 27th. In rejoinder to the reply filed by the respondent number 2, the deputy commissioner, the district commissioner.
You file a reply to what?
To the
affidavit.
affidavit in opposition filed by the respondent number 2, deputy commissioner, district commissioner.
But that is not on record.
It was filed on 27th. I think yesterday being a holiday may not be. Let it come on record.
Okay, Mr. A. Ganguly, the learned counsel appearing for the petitioner, submits that he has filed an affidavit in reply to the affidavit in opposition filed by respondent number 2. Respondent number 2, full stop. However, the same is not on record. He prays for 2 weeks time, let the matter be listed after 2 weeks.
Lordship, in item 6, Lordship, I put on my. Item 6.
Item 6 is gone now, I mean, long time. What can it be, what can be done? Don't come like this.
My lord, I was on leg, Lordship.
Now, you may be on like, but you mention it when the, I mean, when court is rising or court is sitting, not in between.
20.
None appeared for the petitioner when the matter was called for. Let the matter be listed after 3 weeks.
21. 50. 50 minutes.
Yes.
Your lordship had fixed this matter on Thursday, that is yesterday. But yesterday,
Ah,
notification was changed and yesterday was a
yes,
holiday.
yes.
So now, this matter is going to take some time because I'm going to take around 1.5 hours.
What is the matter about?
This is a tender for
Hmm.
off license of a liquor shop
Hmm.
in Sukia.
So you don't want to do it today?
Lordship may fix it on a hearing.
On a hearing,
On 2nd of,
because I believe my learned friend will also take some. time.
2nd of?
2nd of June, your lordship.
2nd of June, lot many matters.
Tuesday, your lordship.
2nd of June is preferable.
16th of June? Or there is some urgency?
Urgency from my side.
Or 16 or 9th of June?
9th, your lordship.
9th of June?
9th, your lordship.
Okay. Mr. Sharma, 9th?
Fine.
9th is fine. But Mr. R. Sharma, the learned senior counsel, assisted by MS P. Fukum, learned counsel for the petitioner, also by Mr. S. Botagul, the learned senior counsel, assisted by P. Khatoniar, for respondent number 6. Respondent number 6. Okay. Mr. N. Goswami for
123.
1, 2, and 3. Mr. Roy for? Mr. Roy for 4. As agreed by the council, appearing for the parties, let the matter be fixed on 11th of June. 11th June. Oh, sorry, 9th June. 9th June.
The interim orders may continue.
Interim orders of past earlier shall continue till the next date of listing.
In fact, of this standing council access will be seen.
Okay, this raised it to reflect the name of the standing council excise in the instant case.
Obliged.
Deeply obliged.
22.
None appeared for the petitioner when the matter was called for. Let the matter be listed after 3 weeks.
23, 24.
My pleasure, Lord. Lordship, we will be filing an affidavit in opposition.
You are appearing for whom?
For the petitioners.
Petitioner, how you will file affidavit in opposition? Have you filed affidavit in opposition?
Lord, I have filed affidavit.
So they'll be filing reply most probably.
But I have filed another petition also that is on record. May I pay for to being on record because I have filed one
When did you file it?
27.
So to yesterday was up, it will come on record.
Lordship,
Yeah.
we will be filing and reply.
You have received that
Yes, Lordship.
additional listing?
Yes, Lordship.
She has received such.
Same matter.
Lordship, after 1 week,
Your name?
DR Bangshari.
So and so for the petitioner, also her Mrs. C.
One,
Borua, the learned counsel, appearing for the respondent, all respondents.
4, 5, and 6, my lord.
1, 4, 5, and 6. 1, 4, 5, and 6. Full stop. Mr. Borua submits that he has already filed his affidavit in the instant case. Please.
My lord, 2 cases are coming from data. I am on 23, my lord.
Now you're on 23. I don't know 23. Huh? The London Council appearing for the petitioner submits that praise for 2 weeks time to file an affidavit, the affidavit in reply in the instant case. Prayer is allowed. Let the matter be listed after 2 weeks. And 24,
It's the same matter.
same.
Same, Lordship.
You are appearing for whom?
Union of India, Lordship.
Okay, give your name, huh? Give your name. So and so appears for. Union of India, Mr. Respondent number 1. You check it. Both the matters will be listed after 2 weeks. After 2 weeks, both.
What's your pleasure?
After 2 weeks.
25.
Lordship, I am taking for respondent number 4, Lordship. The senior engaged counsel is in on leg, course number 1, Lordship.
Who is the senior engaged counsel?
DP Bora.
Hmm?
DP Bora.
DP Bora.
The matter may be.
But nobody is appearing for this.
GMC is also a party. They are basic, I mean.
Are you filing an affidavit, Mr. Nayak? You'll have to
We have
file.
already conducted this meeting. Let us have a decision and file.
Okay, none appeared, you are appearing for whom?
Mr. DP Bora.
You are petitioner,
Private.
private respondent, okay. None appeared for the petitioner when the matter was called for. Though Mr. Your name?
P Jha.
Hmm?
P Jha.
P. Jha is present on behalf of Mr. DP Bora, the learned counsel, appearing for respondent number 4. Mr. P. Nayak, the learned additional, Mr. P. Nayak, the learned standing counsel for
1 and 2.
respondent 1 and 2 is present. Mr. Nayak submits that he requires some time to complete his instructions and file an affidavit in the instant case. 3 weeks time, 3 weeks time is granted for filing the affidavit. Let the matter be listed after 3 weeks.
26.
Wait, please, Lord. Same issue is pending in this.
Huh?
Same issue is pending only in a RSA, regular second appeal. May I pay for disposal of the second appeal and then the right in interest of the petitioner?
Same issue is pending.
My lord.
How the writ has been filed?
My lord.
How the writ has been filed?
My lord, it has been filed only because one notice has been issued by the municipal.
Hmm?
One notice
Hmm.
for my lord,
Notice issued by whom?
by the municipal, my lord, municipal courts for demolition of the my lord house. On the basis of a complaint, my lord, page 30 is the notice, my lord.
So you are challenging that order,
Yes, my lord.
18/7/2025.
My lord. Yes, my lord, RSA is pending, my lord. Sometime maybe, my lord, also that, my lord, the RSA can.
Mr. Datta? So he's saying the RSA is pending, though he has challenged
Yes,
this.
RSA is pending.
Hmm?
RSA is
282
pending
2015.
on this issue. If the RSA can be disposed of early, then it's all right.
My lord.
When is the next date fixed?
My lord, date is not fixed, my lord, it is on the hearing, my lord. Hearing.
Okay, we'll adjourn it for 8 weeks.
Yes,
8 weeks.
my lord.
Okay, heard Mr. PJ Sakya, the learned counsel appearing for the petitioner. Also heard Mr. S. Datta, the learned senior counsel, assisted by so and so for respondent number. Silchar municipal.
Yes.
Municipal corporation, now it is corporation.
Now,
Okay, but
earlier.
for respondent number 1,
One.
anybody is appearing for? Mr. P. Deka. PK Medhi, so Mr. PK Medhi, the learned government advocate for respondent number 2 and 3. Number 2 and 3. Mr. PJ Sakya submits that submits that one RSA.
Being RSA number 282.
RSA number so and so
282/14.
40 on the same issue. No, on RSA involving the same issue. It's not same issue.
But the right tell and interest of the parties, my lord.
Okay, involving the same issue is pending before which court?
This court.
This court.
Yes.
Before this court. Therefore, prayer has been made for adjournment of the matter. Adjournment of the matter so that the RSA can be decided first. Full stop. Mr. S. Datta, the learned senior counsel, has no objection to the aforesaid prayer. Let the matter be listed after 8 weeks.
Status quo order granted earlier may be found.
The status quo order as passed in the instant case shall continue till the next date of listing.
Private respondent here.
MSP Chakraborty, is present for respondent number four, respondent number four.
Oblige.
Much.
27, 28.
What the matters are analogous. Well, earlier occasion, government took time to file affidavit in 2025 matter that 5611 2025. Till that affidavit has been not filed. Well, text also gives that in a second, that first writ petition, that is 9/24/2025, they filed the affidavit and enclosing the
Yes,
well, case of the petitioner is that petitioners agree with the cancellation of his license, the petitioner writer license, Malo.
petitioners,
Petition writer, deed writer, Malo.
read writer,
Malo.
Deed writer.
deed writer.
Deed writer, Malo. There's a license issued by the district authority. Malo. In fact, Malo, case of the petitioner is that initially in the Malo,
What you need, you will file affidavit or what? You have taken time earlier also.
Yes, I have taken time, my lord. In that case, I have not received instruction, my lord. In fact, my lord, he says my record, which on the basis of which, my lord, his deed writing has been cancelled, that has not been disclosed to him, my lord. In that case, my lord, I think, my lord, affidavit which was filed in the earlier case, that will cover, my lord. If necessary, my lord, then. record
Earlier
will
case
be
means
required.
this case, the other one,
924, my lord.
huh?
924, my lord.
924.
Yes, my lord.
924, you have already filed affidavit.
Yes, my lord.
Say similar matter too.
Similar.
similar matter in this,
Mane-
Malo, in 924,
Hmm.
they filed the affidavit enclosing an order that is Annexa A page 65, which is challenged before this honorable court in the.
He has challenged this
New
order,
case.
my lord, in the second petition, my lord.
Then you do one thing, I mean, you'll have to file affidavit then. You'll have to bring your instructions because the order you have passed here, I mean, which has been annexed, that has been challenged in the second read. So you'll have to respond to this read. That will not cover this. That affidavit will not cover.
In that case, my lord,
There's
some
already
time is required.
time, Malo. Due to
Already you have
cancellation of
communicated,
the
my lord.
license,
Hmm.
I am without any job. So matter will be expedited. Other
Yes, Mr. Chetia, when?
Yes, my lord, after 2 weeks, my lord.
the specific date so that.
If I file an affidavit, small affidavit will be required. It will not require much of effort, I think. Heard Mr. U.K. Goswami, the learned counsel appearing for the petitioner. Also heard Mr. M. Chetia, the learned government advocate for all the respondents,
All right.
for all.
For all the. Some revenue is there, my lord.
No, all the respondents, Malo.
For the respondents, for the respondents, full stop. Mr. Chetia pays for a 2 weeks time to file an affidavit in the instant case, full stop. Affidavit in the case. Let the matter be listed. On 11 June.
11.
11 June.
Hello.
Mr. Goswami,
Malo.
11 June, both the matters.
Good time, my lord.
30.
Mr. Talukder, affidavit not filed.
It is not, and our instruction is, my lord, he was occupying 1/3 as annual part-time. Whether he has renewed it or not, that is not known. So in the Sita, the same land has been shown as government trust land and allotted to STC.
So that you'll have to file an affidavit. You are disputing this thing. You'll have to file an affidavit in this
He
case.
doesn't say anywhere that he has renewed the part-time, because annual part-time has to be renewed. Yes.
And then you'll have to bring those facts on record.
That instruction, that much of instruction I have, and there was a field verification. He had a temporary structure over that portion of the land. In one part is lying there.
You bring on record then. Bring on record because you are disputing his these things. None appeared for the petitioner when the matter was called for. Though Mr. B.J. Talukdar, Leonard, additional senior government advocate is present for rest. For? For respondent number 3 and 4. Full stop. Let the matter be listed after 3 weeks. In the meantime, Mr. Talukdar, Talukdar will file the affidavit in opposition in the case.
31, 32.
My lord, Mr. Deenath is in court number 1. Can the matter be kindly passed over the time being? Nothing to it.
Okay, we are passing it over for time being.
My lord, the report of the electrical inspector is awaited.
None appeared for the petitioner when the matter was called for, though Mr. S. Das, V. Das, the learned standing counsel for FEDC is present. Mr. Das prays for 2 weeks' time for to complete his instructions. Let the matter be listed after
My
2
lord,
weeks.
first, government should be supposed to be filing the electrical inspector.
And what about you? You are not filing anything.
No, my lord. Pursuant to the report, my lord, we will file our affidavit, my lord, that whether the fault is on our part. or-
Okay, I mean, let it be there.
34, 35 similar, my lord, same petitioner, my lord.
Same, 34, 35. 34, 35, same, no? Same order.
Same. Like,
Limit. Okay, orders need. Let me say.
49. So the respondent number 7 has filed its affidavit in opposition on the Wednesday. So I need 7 days time to file a rejoinder. It's a matter of unauthorized construction.
I'm for the respondent number 7, man.
Hmm?
I'm for the respondent number 7.
The private respondent.
It is not in the record, matter. Affidavit I have filed.
He has filed on Wednesday, but that's not in the record.
Okay, heard Mr. A. Ganguly, the learned counsel appearing for the petitioner, also heard Mr.
E.K. Borwa, matter.
E.K. Borwa for
Respondent number
respondent number 7. Mr. Borwa submits that he has already filed an affidavit in the instant case. Instant case, full stop. However, the same is not on record. Then you read Mr. Ganguly prays for 2 weeks' time to file an affidavit in reply to the affidavit of opposition in the instant case. Let the matter be listed after 3 weeks.
Can a date be given?
No, after 3 weeks.
So there's an interim order that.
Interim orders who are passed earlier shall continue till the next date of listed.
Please, my lord.
Yes, Borwa.
I have not seen the learned people.
PP's office. Madam Mohanto, can you find out anybody is there? We'll take it up after some time. Then.
Of course, Your-
You just be here. We want to finish it off.
yes,
Pending.
of course, my lords.
CD has come.
I'm not aware, my lords, the BP is not.
Okay. Mr. Sharma, you are there?
Somehow we have reached the matter, Lordship.
Ah.
Nobody has been elected in this court inadvertently.
You have missed it out. We just wanted to hear this matter. It was very, important issue was involved and we want to decide this issue.
Then Lordship, I will just find it out who appeared.
Just find it out. A small, issue is involved. You can find it out. See, the issue is simple. Arrest memo, whether signature is mandatory or not. If section 48 notice has been given.
That Lordship, there are some contradictory views of the.
We want to decide this. Contradictory means like they are factually may be different here and there.
Yes.
So at the same time, if section 48 notice is given, whether a statutory mandate given under section 36 can be waived off
Lordship.
only because 48 notice is given. That is the issue.
Then we'll have to place the mandate of 36, Lordship, how it has come, Lordship, that needs to be.
That's why matter has been fixed. We have been here. I have heard another matter,
Yes.
but this matter, I think, I could have decided at the same.
So if Lordship permits, can it be next week, Lordship?
No, next week can't be like that matter already. I have heard it. I need to pass the order today itself, not further.
Then after some time.
You just go through it. This court has already heard one matter.
Yes.
And we have already almost decided what is to be done, what is not to be done. But some kind of assistance from your side and his side. What are your views? That would be helpful. We can take it up in the second half, Mr. Borua. Let him also go through it, Mr. Sharma. But CD is also not there probably, right?
No, no.
Hmm?
ECR was.
PCR, sorry,
ECR has not been received.
Hmm?
Yes, ECR has not been received.
PCR not received. Then I can't hear this matter also.
Next week also. In the meantime, I will be able to place some observation of the.
But we have already heard a similar matter. I'll have to pass the order today. I can't keep it waiting. So whatever order is passed, that will cover his case.
Lords, in that case, I may be heard.
No, I can keep this the other petition pending for your matter. Doesn't come, that will cover you. Or if it doesn't cover you, then you'll have to look for some other option. Whatever is there.
My lords, I have come prepared with my submissions. ECR is not here.
You have annexed all the documents, sir?
My lords, all the documents are here, certified copies.
Mr. Sharma, only thing is that TCR only we require for whether this formats are properly done or not.
Understand.
And what time it was given, what time it was not given.
If my lords is pleased to go with the certified copies and decide the matter.
After some
The
time.
problem is that, Mr. Sharma, we have already heard another matter. And I was waiting for this matter also. If it comes, then otherwise it will be difficult, no?
Yes. After some time.
We have already heard it and I have already decided. The only thing is that I just waiting. If anything comes from both of you. After some time,
After some time.
maybe in the second half.
After some time, Lordship. Half an hour.
You just see if there is something.
Yes.
This is not a legal issue, nothing else.
Yes, yes.
Only a legal issue. Okay,
I'm so obliged.
after some.
My last order, I was given some time lordship
Hmm.
to get the steps, correct address lordship and take steps. But I wrote to the my lord, the petitioner lordship, no reply is come lordship,
What is to be done?
lordship. Now probably the party is not interested lordship.
So you withdraw it.
Oh, it liberty lordship.
No, liberty, no.
It suggested lordship. Because I could not, my lord, communicate, my lord, the reply does not come lordship.
What was the case?
This is my lord, like civil, my lord, the, some, lord,
What is the dispute?
enforcement is their lordship,
Hmm?
my lord. Anyway, it may be, I may be allowed to withdraw lordship. I will, my lord, if necessary lordship.
Okay, heard Mr. M.H. Ahmed, the learned counsel appearing for the petitioners. If Mr. Ahmed prays for withdrawal of the case, the case is dismissed on withdrawal.
And liberty.
The liberty cannot be.
I'm appealing for 3 and 4.
Hmm?
I'm appealing for
Mr.
3
S.S. Roy for respondent number 3.
1, 2, my friend Ravi.
Mr. J. Hendrick for
1, 2. 1 and
G. Hazarika for 1 and 2.
Several time I wrote lordship to.
Yeah, I mean, it cannot be gone like this. So many times it has been taken.
All right. 47.
May I please? Well, in this contempt petition, on the last occasion, you already directed them to file affidavit.
Hmm.
The previous and application of betting, but as per my instruction, payment has been made, your lordship.
Hmm?
Payment has been made.
Even has been made.
My lord, but the interest part is not paid.
Interest part, if we are disputing it, if they want the interest part, they will approach the MSME council because they are claiming
No,
this.
my lord.
Yes.
No, my lord. At this stage, my lord, there is no question of MSC council, my lord. There is already an order. That is a consent order, my lord. My lord, in so many cases, they have paid the amount pursuant to the order of High Court, my lord. Now they are saying that I should go to Constituency Council. My lord, this is the order. In so many cases, my lord, they have paid the amount, interest amount. Now they are coming up with the interest part. I should go to MSC Council. Through RTI, my lord, I have obtained some instructions wherein they have said yes, they have paid the interest amount after order of the High Court. This honorable court, my lord. But otherwise, my lord,
But it says with the interest.
It's the
My lord-
order says the considered representative so and so file a petition of making payment of outstanding dues with interest with a period of 3 months.
Hmm.
Now the interest part comes if they are registered under the MSME at that
Yes,
point of
exactly,
time
my lord.
when they did the.
No, that issue was not raised when the order was
Everything is
passed.
raised, but we have to verify whether they were within the they were registered within the MSME or not. And as per my instruction, we cannot verify any documents submitted by the petitioner whether they were MSME or not. So that's why we are
No,
saying,
that issue was raised when this order was passed.
no, that issue was not.
Then
Never, my lord.
Now they say we have to verify. We verify it.
you verify whatever you do, but like the order, what has been passed, you have to comply with.
Payment has been made. The thing, the
No,
issue,
payment with the interest.
it says considered. It says that verification has to be done, your lordship.
Having regard to the submission made so and so to consider the representation so and so filed with a petitioner for making payment of the outstanding dues with the
Amount,
interest
Interest.
interest
of 3 months.
within. So if amount is due, then interest will be there. The verification only for the amount.
Exactly.
We have paid the principal amount.
Verification only for the amount. So amount you are supposed to verify. If amount is paid, then along with the interest is to be paid. That is the order.
That interest calculation we have to done on basis of MSME certificate. That there were issues now where the verification taken place. The MSME we cannot verify whether he was registered under the MSME or not. That's the issue.
My lord, you have to kindly.
If you are disputing, if you are disputing the interest amount, there is a Constitution Council.
It is
There's
a
an
small
MSME
state
Council.
industrial unit duly.
I mean, if the party is not an MSME, then first of all, he cannot apply under this act.
My lord.
Correct.
100%.
His case will not be considered under this MSME Act, MSMED Act. His case cannot be considered. You have considered his case. Why?
We have just paid the principal. But the
Forget about the
MSME
principal. What is the order? The petitioner unit is a registered micro, small, medium enterprises. How this statement has come in the order then?
Because at that point of time, they have submitted the documents before the court that they are registered. But now the issue is that when the work was carried
Then
out,
you should have contested the case saying that this is not correct.
we have started.
You should have contested
Yes.
the case saying that this is a fake document or they are not registered.
My lord.
This order could not have been passed. Then this order was passed on the basis of that.
But the verification part was carried out.
Verification part only for the amount, not for MSME or something like that. The order is not like that. It is specifically stated petitioner is a small industrial unit registered under so and so. Then you should have objected to this saying that no, this is not correct. We need to verify it whether he is or he is an MSME or not. You haven't done so. Now how can you come up with another plea saying that no, we'll have to verify this? This order is already passed on the basis of that.
Yes, Your Lordship, it's true that order is passed, that they were registered. But my submission was that we need to make necessary verification.
You need to do necessary verification about the amount calculation.
Yes, we have done that.
Then
That after calculation, we have seen that we cannot verify whether they were MSME at that point of time.
then how this order is passed?
That-
How this order is passed?
So we have to pass speaking. They were said to certify. We have to verify. We verified
No,
it.
verify what, Mr. This order is passed because it is an MSME industry.
It was his contention, Lordship.
Or his content, you should have contested it. Have you contested it?
But we
Then-
said we'll verify it. We'll verify after verification. We seen that their
They have never
MSME
disputed,
documents,
my lord, that
the
question,
MSME
my lord.
documents are not with us. That's why only the principal amount has been paid.
My lord, another Supreme Court has said first interest part has to be paid, then only question of, my lord, principal amount will come. I've given the, my lord, our High Court judgment, my lord. First interest part has to be paid, then question of, my lord, principal amount will come. In so many cases, they have paid, my lord.
You are Mr. R. Gogoi.
Yes, Sir Lordship.
You were there in the case.
Yes, Sir Lordship.
Then why didn't you contest it?
Because at that point of time, we were not getting any
See, you were not getting any instruction. Whose fault is that? You were not getting any instructions from your department. Whose fault is that? Now, this order is passed on your face.
Yes, Sir Lordship.
Then, after the order is passed, order specifically said the amount with the interest. Then how can you say that you don't want to pay interest? How
We
can
are
you
not
say
saying
so?
we will not pay.
Then,
I'm saying-
then you verify whatever you do. You pay him the amount. That's what I'm saying.
Very well, Lordship.
You'll have to pay him.
No affidavit, my lord, no review, my lord.
It specifically says petitioner is a small scale industry duly registered under the Director of Industries. As such, the petitioner unit is also a registered micro so and so, so and so. Then while this thing was recorded, he should have told the court that this is not correct.
My lord.
Now, on the basis of this, court has passed this order. Court has passed an order specifically saying that we will have to pay the interest also. And interest was a specific claim here. MS Hazarika submits that any default on so and so, the interest has to be paid. You are, I mean, while you were there, this order was passed.
Yes, Sir Lord.
Then how can you then say that like now, no, we want to verify whether it's an MSME or not? We can't do that. Once the order is passed on the basis of the fact that the industry is an MSME, then how can you say that? So when are you going to pay him interest? Tell me.
Lordship, I'll take instruction in let it come in 2 weeks, Sir Lordship.
I mean, it cannot go on like this. There is nothing to take instruction in this. You tell me when can you pay?
7 years, my lord.
Let it come after 2 weeks, Sir Lordship.
You read the order properly. Have you read the order properly?
I read the
What the order says?
Says that we will consider representation if this
Have the court says that no, there is a contention whether this industry is MSME or not. So you verify that. Is there any order like that? Then why are you raising the question now here? Once the order is passed on the factual basis that it's an MSME. Now we cannot raise that issue. Okay, let him take
My lord,
instructions.
may I pray, my lord?
Let him take instructions.
My lord, let them file affidavit, it is better, my lord.
He file an affidavit otherwise. No, let him take an instruction. If they pay it, what is your point of filing affidavit? See, you cannot avoid this order. You tell your department also, it can't be avoided. You cannot avoid this order. You just keep this thing
My
with
lord,
him.
after a week, my lord.
Let it be after 2 weeks. Let him take instructions.
My lord, date may be fixed, my lord.
Let him take his. Okay.
My lord, that may-
Heard Mr. R.K. Agarwala, the learned counsel, appearing for the petitioner. Also heard Mr. R.R. Gogoi, the learned standing counsel for PHE department. Full stop. Mr. Gogoi submits that he requires 2 weeks time to get the instruction as far as payment of interest is concerned. He submits that the principal amount has already paid.
My lord, already paid, but.
No, you have received.
I have received.
Principal
my lord.
amount has
Only
already-
One thing, my lord, may I submit, my lord?
Hmm.
Supreme Court has said in so many words,
No, understood, understood.
that first interest part has to be paid.
No, they're disputing interest part, that's why they haven't paid. Anyways, you can write, as far as the interest part is concerned, interest part is concerned, the principal amount has already been paid to the petitioner. Let the matter be fixed on, 11th of June.
Let it
Let
be
them-
part, my lord.
Let the matter be, no, this cannot be kept far. Let the matter be listed on 11th August, sorry, June. 11th June. You bring your instructions. It could be, I don't think, Mr. Gogoi, it will be fair on your part to deny this now. Once the order has been passed on the basis of the fact that this is an MSME, now you are disputing that whether it's an MSME or not, then this order, the whole order has to go then. You'll have to file a review then. It will be difficult for you.
Well, interest part is that they are paying selectively to someone, not paying to someone.
Obliged, Lord.
Obliged, Lord.
48.
None appeared for the petitioner when the matter was called for. Let the matter be listed after 4 weeks.
49.
May I plead the lordship? As per Lawazima Court order dated 19/5/2026, neither AD card nor answer notice has been returned in respect of respondent number 11. The last part also for order.
Respondent number 11.
11,
So you take a fresh steps for.
yes, within 2 days.
Okay. Heard Mr. D. Chaudhary, the learned counsel appearing on behalf of the petitioner. Also heard Mr.
Yes, to.
S.
Yes, to.
H. Chaudhary, the learned counsel, appearing for
Other respondents, 6, 7, 8, 9.
all other respondents.
No, here.
You are appearing for whom? Tell me, you are appearing for whom?
Private respondents, except respondent number 11.
Mr. Chaudhary appears for private respondents, except respondent number 11. Then you read Mr. S.S. Roy for 3 and 4, G. Hazarika for 1 and 2. As per the Lawazima Court proceeding dated 19/5/2026 reveals that no AD card has been received so far as service of notice on respondent number 11 is concerned. The learned counsel appearing for the petitioners has placed for 3 days time to take fresh steps for service of notice on respondent number 11. 3 days time is granted for taking appropriate steps for service of notice on respondent number 11. Let the matter be listed after 2 weeks.
40.
This matter is under petroleum rules, my lord. Act and rules. Your lordship is aware that the party has to approach the district judge with regard to compensation. Here he is challenging the order of circle officer, which passed the order. That is page 18, my lord.
But no one is there. Who is appearing? Some S.J. Sharma or Kushilal. Counsel for the petitioner expired. Oh,
There are other advocates also, my lord. I think matter has to go back to the district judge, my lord. Honorable district judge. They are challenging.
D. Chutia is also there. Somebody D. Chutia. We'll post it after 2 weeks. Let's see now next date, what happens. None appeared for the petitioner when the matter was called for. Though Mr. J. Roy, the learned senior counsel assisted by so-and-so, is present for the private respondent. Private.
Respondent number 2, 3, madam.
Respondent number 2 and 3, Mr. S.S. Roy for 4 and 5, G. Hazarika, number 1. Let the matter be listed after 3 weeks, after 3 weeks, after 2 weeks, okay, after 2 weeks. Mr. Roy, are you aware of Mr. D. Chutia, who? Just check and if possible, intimate.
I also try to find out, but.
Please find out if.
What do you want?
In this case, kindly perusal of the last further matter. Caste certificate has not issued to. Caste certificate has not issued to us, my lord. SC certificate.
They are saying it is under process, they are doing it.
Yes, under process.
Yes, Mr. Sunwal, your name?
Arsangi, Arsan.
Arsangia, yeah, what happened?
Here we have received an instruction.
What is the instruction?
Lordship, the new incumbents has come in and they will be appointing an inquiry committee and to inquire into the matter. Lordship, if I may submit this.
What was the High Court's order?
That is, my lord, page 16. DC had already, my lord, submitted all papers. My lord. Verification has been done.
The requisite applications where have you filed? When did you file?
My lord.
Huh?
That was submitted, my lord. But verification already done. Verification completed.
No, then why have you filed this contempt case?
No, no. my
Where
lord.
is the
After
contempt?
After filing this contempt case, verification done, my lord.
Hmm.
Communication letter also issued to us, my lord.
So verification done.
Done, my lord. But the concerned person, my lord, this letter was also issued, my lord. One Golab Das, my lord, who is the, my lord, committee's member, he has not. Possibly this Golab Das has been already, my lord, is not present incumbent. That's why this committee again, they start.
Then wait for some time then.
Yes, my lord.
No, wait for some time. Heard Mr.
H. Das.
H. Das, the learned counsel. I keep all these things with you. Heard Mr. H. Das, the learned counsel for the petitioner. Also heard Mr. So-and-so, the learned counsel appearing for the. You are appearing for which respondent?
Sole respondent.
Sole respondent. No, there are many respondents. 3 respondents are there. Mr. Nath is appearing on.
For the district commissioner, I am appearing.
Dis-
Number 1.
Number 1. Okay, Mr. D.K. Nath, the learned counsel for respondent number 1. Full stop. Mr. Nath submits that the process is ongoing and it will require some time. Full stop. Let the matter be listed after 2 weeks. After 2 weeks.
Lots of date may be given.
After 2 weeks. None appeared for the petition, none appeared for the petition when the matter was called for. Let the matter be listed after 3 weeks.
The contempt matter for willful disobedience of an court's order dated 8/8/2020. On the last occasion, has been directed to indirect line by the
Follow the
deputy commissioner.
Lordship, I prayed for 3 weeks time here. Lordship, I'm awaiting the instructions because the incumbent, he joined after the appellate. At the time of filing, he was not there. Awaiting some instructions I have received, but some clarity is required. My lord.
Only the submission is that lordship, this case and the cause of action arises on 2020. That this is the second round of litigation. The land has been acquired, that has been released, the requisition compensation has not been given till date. That is
Land
the-
has been acquired,
and
then
that has been released also.
that has been released.
It's released also. The requisition compensation not
It
given.
was requisition
Aye.
and subsequently de-requisition.
The requisition.
So it is with them, land is with them, but the
Land.
in between.
Okay,
the-
let him complete his instructions.
Lordship. Only the prayer is that the next date may be fixed.
Let him come up with his instructions.
Lordship.
Your name?
A Deka.
Mr. A. Deka, the learned counsel, appearing for the petitioner. Also heard Mr. D. Nath, the learned counsel, appearing for the sole respondent. Mr. Nath prays for some time to complete his instruction in the instant case. Let the matter be listed on 11 June.
Lordship.
Lordship, pursuant to the last order, I filed an amended cause title. Respondents number 6 to 15 have been completed recently.
Who?
6 to
6 and
6 to 15. Lordship.
6 to 15.
Yes. But the matter concerns a no confidence motion.
So it will, notice will go.
Yes, Lordship. But they have filed an impleadment.
You are appearing for some
Corporation Department, Your Lordship. 2, 3,
corporation
and 4.
department. Okay.
Lordship, they had filed the impleadment that was allowed. They had filed an impleadment.
Impleadment who has filed?
Respondents number 6 to 15. That was allowed. I have thereafter filed an amended cause title. Lordship.
Okay. A notice has to go otherwise also. Okay, heard Mr. A. Atria, the learned counsel appearing for the petitioner. Also heard MS so-and-so, the learned standing counsel appearing on behalf of PNRD department,
Corporation Department.
co-person department, full stop. Amended cause title in the instant case has been filed by impleading respondent numbers
6 to 15.
6 to 15, full stop. A notice may be issued to the, all these are private respondents.
Private respondent.
Notice returnable in 4 weeks to be issued to the newly impleaded respondents by way of speed post. Full stop. Steps for service of notice will be shall be taken by the petitioner within a week, within a week's time. Full stop. Let the matters be listed after 4 weeks.
So there's an interim order that may be
Interim order so passed earlier shall continue till the next date of listing.
published.
Right.
45.
May I please, Your Lordship?
Yes.
For the order of this honorable court, 10th of March 26, I have filed an impleadment petition, Lordship, for the impleadment of the respondent as respondent number 8. Lordship, in IN number 1404.
Amended cost title filed. Amended cost title filed.
No, no.
My lord, what
Implement,
has happened is that
You have filed an implement petition.
yes, Lord.
This, this is for implement,
Yes, notice is to be issued.
not, okay, okay. So he is filing this IA for implement.
Lord, what has happened is, my lord, the respondent number 6,
Hmm.
during the pendency of the instant writ petition, my lord, there has been a transfer of hands, my lord. The estate has been transferred to one M.K. Shah, the new incumbent, my lord, as per the order dated 10th of March. The petitioner has been directed to implead the new incumbent, my lord.
MK Shah.
Now, my lord, in the meantime, respondent number 6 has filed an IA for striking out their names from the instant proceedings, my lord.
No, that already implement petition direction has been given, that has to be heard then.
No,
One direction has been, where is that order, 26 March,
10th of March.
10th of March? So you are appearing for the new incumbent?
My lord.
Who? Who is
I am
appearing
for
for
the
that?
respondent number 6.
You are for the respondent number 6?
Yes, my lord. The respondent number 6 has transferred the tea garden to the new incumbent, my lord.
My lordship,
MK
garden
Shah.
has not been transferred. A agreement has been executed for selling the land by McLeod Russell India Limited in favor of Shah Exports Limited, lordship. An agreement to sell does not give any right title interest, lordship, until and unless sale deed is executed. So there is no question of a striking out, against which I have filed my affidavit in opposition on 30th March 26. But that has not been tagged to the record. Simply today, lordship, implement petition notice may be issued.
Okay, heard Mr. S.P. Roy, the learned counsel appearing for the applicant. Also heard MS N. Upadhyay, the learned counsel appearing for respondent number 6, respondent number 6. The instant I has been filed for impleading,
MK Shah Exports.
impleading one Messrs. Messrs. MK Shah Export as respondent number 7.
8.
Respondent number 8 in the connected repetition, full stop. Let notice be issued, returnable in 3 weeks. Returnable 3 weeks. Steps to be taken by way of speed post. By way of speed post within a period of within a week. Full stop. Let the matter be listed after 3 weeks.
Obliged.
Mr. J Handicap appears for 3, 4, and 5.
Lordship, a registry may be directed to place on record my affidavit in opposition.
Now that will come from. When did you file it?
30th of April.
30th of April. It will come. It will come.
Okay.
51, condition. Order.
None appeared for the petitioner when the matter was called for. As per office note dated 27/5/2026, service report is awaited. Full stop. Let the matter be listed after 2 weeks.
52.
We have received our instruction.
Hmm?
We have received the instruction.
What is the instruction?
Lordship, that the beneficiary, details of the beneficiary has been uploaded to the DBT portal. And the amount will be released within 2 weeks, Lordship. Lordship may verify. This is relating to ex gratia payment, Lordship.
We'll list it in the next week, let him come, then we'll dispose it off. You keep it with you only. None appeared for the petitioner when the matter was called for, though MSG Hazarika, the learned counsel is present for
Number 1.
respondent number 1. Respondent number 1. Let the matter be listed after the week.
53.
Lordship, in the matter as per order, office note dated 27/5/26, unserved notice has been received back from respondent number 2, and neither AD nor unserved has been received back from R1.
So we'll wait for some time.
Lordship, there's an urgency in the matter.
No, we'll wait for some time. It was notice was issued only on 22nd April. And this has come back on, this was issued on 27/5 to, no, issued on 22/4. So we wait for some time. What is to be done otherwise?
We may be allowed to take steps by.
No,
as
let us wait for one more date. Or let's wait for one more date. Now all contempt cases are urgent. Heard MS so and so the learned counsel appearing for the petitioner. As per service note, as per office note dated 27/5/2026, the notice is yet to be served on respondent number 2. Await service report, let the matter be listed after 2 weeks.
31-32.
Look, item number 31 is relating to appointment of special PP under SOC. But I have sought for the instructions from the LR. I am awaiting the instructions. He has said that it is under process, but 2 weeks time is required. And in the other matter, Lordship already, order is operating. I think kindly give us 2 weeks time so that I can bring the instruction.
Other matter is for what?
Other matter,
We have challenged, there was a appointment made on special PV in violation of the act. That is under challenge, that has been stayed.
That has been stayed. So now they're going for a new one. New one and the process is on.
Lordship.
Well, there is a IA file, item number 31.
IA can be disposed of probably, or what?
My lord, I have a strong objection.
Huh?
I filed an application for impeachment. We may be, I may be impeded.
My lord, I have a strong objection to his impediment because he's not at all an affected party here. My lord, my writ is, well, how can he be affected even if he's the accused? I am just seeking for an appointment of a special PP in a case where I am the informant. How can he be accused?
He said that he's accused.
My
How
lord,
can
I'm
he?
so sorry. How can he be affected even if he's the accused? How can he be? I'm just seeking for a appointment of a special PP, my lord.
That the reason why I filed the impeachment is, in the other case, there was a clear violation of the act. There has been repeated attempts to interfere in the process.
My lord, I'm in agreement with him in his matter. That should go, my lord. I'm in total agreement with him in his writ, my lord. That is entirely wrong. It should be set aside.
No, the only issue is that like appointment of the special PP, right?
Exactly. My lord, the proposition.
Done fairly.
Well, the proposition of law is
In accordance with law. That is.
No, so we'll do one thing. We'll give him some time. We'll wait what happens on the next date. I mean, we'll not dispose of this also. We'll let it be like this.
My lord, with all due respect, can this be the last opportunity that has been granted, because they've taken several dates. My lord, and the matter in Diffu in Karbi Anglong,
because of a lack of a special PP is getting delayed, my lord.
No, it's a state's concern also, I think, state's concern also.
I'm in agreement with your, whatever falls, but this is just a small.
I mean, but it's a state's concern, so Mr. Nath, you should do something fast.
Lordship, some
Not
instructions.
only for this particular case, but like there may be so many cases pending
Exactly,
there.
there are many cases.
So
which
many
are
cases
pending.
pending there. So 2 weeks time, 2 weeks time,
My lord,
2 weeks time, he should be appointed. I mean, somebody should be appointed.
the judicial department is awaiting the name from the district commissioner and that has not come, but it is under process of the name, once the name, so they are taking the steps. Hopefully within 2 weeks. it will be done.
Okay, heard, Mr.
A Mir.
Huh?
A Mir.
A.K. Mir.
A Mir.
A. Mir, the learned counsel appearing for the petitioner, also heard Mr. D. Nath, the learned senior government advocate, for
The
appearing for
respondents.
appearing for the state respondents, and Mr. I. Chaudhary, the learned counsel. But you are not yet implicated in the case.
I'm appearing for the petitioner in the other.
Other matter. Okay. Then you write, don't write his name in this case. Then you write that Mr. Nath submits that the process of appointment of special PP, POCSO, in the court of, which court?
Caribbean law and
In the court of district judge. No, special judge POCSO, Gifu is on, and the same will be done in a short while. However, he prays for some time to bring in exact status of the appointment, and he seeks for 2 weeks time for that. Full stop. Let the matter be listed after 2 weeks.
My lord, with all due respect, may a date be fixed, my lord.
After 2 weeks, let them come after 2 weeks. And other matter you write, other matter is filed by you. Mr. I. Chaudhary, the learned senior counsel, assisted by Mr. A. Ahmed, is present for the petitioner. You are also there in the party.
I'm not a party there.
Who is party there?
the state respondent is part.
Okay, Mr. D. Nath, the additional Mr. D. Nath's senior government advocate is present for the state respondents. Both the matters may be listed together, huh? After 2 weeks.
Okay.
I'll just come back
to it since my lords has requested me to assist this court in arriving at a correct decision. I have put a certain judgments, if I may take my lords through that. The first in point is DK Basu, my lords. I'll directly take my lords to the guidelines, the operative portion in para 34. If I may read, if my lord has the para. In addition to the statutory and constitutional requirements to which we have made a reference, we are of the view that it would be useful and effective to structure appropriate machinery for contemporaneous recording and notification of all cases of arrest and detention to bring in transparency and accountability. It is desirable that the officer arresting a person should prepare a memo of his arrest at the time of arrest in the presence of at least one witness who may be a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. The date and time of arrest shall be recorded in the memo, which must also be countersigned. Next para. We therefore consider it appropriate to issue the following requirements to be followed in all cases of arrest or detention till legal provisions are made in that behalf as preventive measures. Here, my lords, the relevant portion is number 2. The police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may either be a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. It shall also be countersigned by the arrestee and shall contain the time and date of arrest.
That we are aware, huh? We are aware. I mean,
So,
let us cut this short. Okay,
yes.
DK Basu, we are aware.
My lord,
And subsequently, after DK Basu, 2 amendments have come.
Yes, ma'am.
One is 2005, another one is 2010.
8,
2010.
My lords,
That
Criminal Procedure Amendment Act of 2005.
2005 is for
They
bringing in
section
48.
Yes.
48,
Yes,
50A.
The erstwhile 58.
50A, now 48.
48, yes.
And 36, and then
Thereafter, lords, Criminal Procedure Amendment Bill 2008 that introduced various sections from 41A, 41B, 41C, 41D.
2008 or 2010?
2008, my lords. I have given a copy, my lords.
1 second. But this CRPC, if you have CRPC,
Yes, madam.
CRPC says inserted by Act of 5 2009 with effect from 1/1/2010. If you go to the bottom,
Yes, my lords.
then it says inserted by Act of 5 2009,
Yes.
Section 6 with
Yes.
effect from 1/11/2010.
My
So,
lords,
so it should be 2009.
My lords, in my bad act, it's written inserted by. Code
This
of
is a
Criminal
bill,
Procedure.
this is a bill you have brought in.
My lords, it's written inserted by Code of Criminal Procedure Amendment Act 2008.
The 2008 bill you have got it.
My lords, this is passed by both the legislatures. It has been written, my lords, on top, as passed by both the houses of parliament. Perhaps it's on the next page. So this is after the bill has been passed,
Correct. After the bill has been, so what you are producing before this court is the bill.
which has been passed, my lords.
Yeah, after bill is
Yes.
passed, then
Yes.
there will be act.
Yes,
So
yes.
act is 2009, 5 of 2009.
My lords, my lords.
And with effect from 1/11/2010. Do you have that act?
My lords, I don't have the act. I brought in the bill to show my lords the insertion of the sections.
Correct.
As to why it came into being.
Correct.
Pursuant to the decay
So,
guidelines.
correct. So you show me the relevant portions.
My lords,
Let us take first this thing 2005.
yes, my lords. As in 2005, if I may take my lord's kind attention to section 7 of the amendment. It's on the third page. 7, insertion of new section 50 capital A.
1 second. Page what? Page
My lords, count the third page.
Third page.
Yes, clause number 7, my lords.
Clause number.
Insertion of new section 50 capital A.
Yes, 50
If I may read. After section 50 of the Principal Act, the following section shall be inserted, namely 50 capital A.
So this, I mean, there is no ambiguity to this.
Yes,
This has been brought in.
Yes.
Is there any objection reasons given here?
My lords, I had tried to look into the parliamentary debates also, but not much discussion has been made on this particular section, except the fact that it was introduced pursuant to the directions of the Supreme Court.
Where is that?
My lords, I don't have that as of now. It's in the debates. I can produce it subsequently, my lords.
Okay, anyways, let's see. 50A has been brought in by way of the
An
Act of 2005. Number 25, it says, huh?
Yes.
25 of 2005.
My lords.
Yes, Act of 2005, correct.
Yes. So earlier 50 was there, then 58 came in, pursuant to the directions. Then, my lords, came the 2008 bill, as your lordship has kindly pointed out, it is an Act of 2009.
So that brought in this arrest memo.
41B.
That brought in arrest memo.
Yes.
So what is your argument on this?
So,
what is the point? What is the point you wanted to make?
My lords, the point that I'm wanting to make here is that section 48 was not there when the CRPC had commenced. Neither was 41B. Now we know that in DK Basu, the Honorable Apex Court realized that there has been a lot of procedural violations in custody, torture, and death, and therefore these guidelines were issued. And if my lord looks at each of these guidelines, those find place in the current provisions in the CRPC as well as BNSS in one section or the other. Therefore, my lords, my submission is that if each of these guidelines were not independent and necessary in its own right, the legislature in its wisdom would not have inserted each of these guidelines as a separate right. And therefore, when by 2005 Amendment Act and 2008 Amendment Act, when these sections are brought in, each has its own purpose. And therefore, my lords, the settled principle of interpretation. I have also relied on a judgment of Sati Devi, where it says the golden rule of interpretation. When the intention of the legislature is clear, if my lord, Sati Devi versus Prasanna, the Apex Court judgment, 2010 judgment. If I may take my lords to page number 674, para 10.
Para 10.
Yes, 674. Down below, my lords.
Yes.
If I may read. Before proceeding further.
One second.
Para 10, my lords.
Para 10.
Yes. Placidum H.
Which page, which page?
674, my lords. The page number is at the top left.
Yes, yes, yes.
Down below para 10, my lords.
Before proceeding?
Yes, before proceeding further, we may notice two well-recognized rules of interpretation of statutes. The first and primary rule of construction is that the intention of the legislature must be found in the words used by the legislature itself. If the words used are capable of one construction, only then it would not be open for the courts to adopt any other hypothetical construction on the ground that such hypothetical construction is more consistent with the alleged object and policy of the Act. The words used in the material provisions of the statute must be interpreted in their plain grammatical meaning, and it is only when such words are capable of two constructions that the question of giving effect to the policy or object of the Act can be legitimately arise.
One second, Busho. One second. মোৰ টেবুলত এনেকুৱা ৰঙা ফাইল এটা আছে মেইল এটা শুনিছিল যে সেই ফাইলটো অকণ লৈ ল'ম তাত এটা হেৰি এটা আছে ফাইলটো নাহিলে বহুত তাৰ ভিতৰতে এটা জাজমেণ্টটো লিখি থোৱা আছে আৰু মোৰ ওপৰতে আছে Yes.
We continue, my lords. The other important rule of interpretation is that the court cannot rewrite, recast, or reframe the legislation because it has no power to do so. The court cannot add words to a statute or read words which are not therein. Even if there is a defect or an omission in the statute, the court cannot correct the defect or supply the omission. So, my lords, the rules of interpretation are clear. When there is an express provision by the legislature in the statute that such a provision independently exists, therefore, for this honorable court to take an interpretation that substantial compliance of another provision is also substantial compliance of this provision, perhaps may not be a correct position of law in light of this.
The question comes, I mean, this 36C,
my lords.
36C gives a rider.
My lords.
Okay, it says that if the memo is not signed, by a family member, then he has to be intimated. I mean, the family member has to be intimated. But there is a little bit difference there. Difference, my meaning that if you see, you take up 36,
my lords,
36B.
My lords.
36B says,
yes, prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made.
So it, first of all, it uses one word that is every police officer while making an arrest shall. They have used the word shall.
Mandates.
Then they say, B says, attested by at least one witness who is a member of the family.
Right.
So there is no ambiguity to that,
Yes.
Mr. Sharma. There is no ambiguity to that. A member of the family, correct? So he has to be a member. He can't be a friend. He can't be a person of the locality, or he's a person who is working with him. No, nothing doing. It's a member. Then if you come to C,
well, there is an or.
One second, C.
Or a respectable member.
It is understood. We are concerned with the family.
Of course, of course.
So C says what? Inform the person arrested unless memorandum is attested by a member of the family that he has a right to have a relative or a friend or any other person. So it has widened the thing. Correct. The widen the scope, saying that if it is not family member, also family member, if family member hasn't signed it, then the person will have a right. He can name a person, and he can be informed.
You can say that it has given an option. She has given an option. In absence of this can be done.
Correct. But the mandate of a witness is still there.
Yes.
See, if it is not a family member, then you'll have to take a witness mandatorily.
Yes.
The witness, there is no exception given in 36. That witness, only because you are intimating the family member or a friend or somebody, that the witness is not required in the 36. But there is no exception given there. There is no exception given there at all. It says a witness or a family member. That means if family member is not there, then witness has to be there. There is no avoidance. You cannot avoid that. There is no ambiguity there. Either a witness respectable member of the locality or a family member. So if family member is not there, witness has to be there. How can you avoid witness? And another thing, Mr. Sharma, he's arguing for his case, so he's arguing for, he's saying that compliance. The other two, I have already written one, this thing, because we have already heard one matter. So I just kept it pending for 2 days so that I can hear him out also. So, in that case also similar situation happened. So now see, one thing you'll have to realize, this section 36 has been brought in later on.
Yes,
But 48 was already there.
yes.
So if 48 is already there, what would be the legislative intent to bring in 36 and specifically say that you'll have to you'll have to take a signature of the family member there?
That Lordship, my respectful submission, Lordship, subject to correction, Lordship, it has come from DK Basu, that much is very clear. Now, Lordship, DK, the whole premise of DK Basu was, Lordship, custodial torture, encounter and so and so. To bring, Lordship, transparency in the arrest that was given, Lordship. And Lordship, if Lordship kindly goes to the DK Basu guidelines once again, there is also that option. That option.
The option is there. I have seen that.
Yes, that option is also given in the guidelines.
That is there.
Yes, that is always there. And another thing, Lordship, subject to your Lordship correction. Lordship, this DK Basu case, it was delivered on a date, Lordship, when NDPS was not in force. That is very essential, Lordship, because NDPS came later on, Lordship.
Correct.
And NDPS, Lordship, section 37.
NDPS came when?
In
1985, my lords.
yes.
NDPS came 1985, and these amendments have been done when?
2005 and 2008.
DK Basu was.
Correct. So DK Basu has given a guideline.
Yes.
So DK Basu did not say that you incorporate as it is whatever we have said.
Yes.
Correct. So amendment has been brought by the legislation.
Yes.
And legislation, with in spite of knowing that section 48 is available, already available in the code, but still they have brought in this.
Yes.
There must be some reasons.
Yes, Lordship.
But the reasons may be because 48 doesn't say about timing.
Lordship.
So now interpretation has come.
Yes.
By Bhiyan Kumar's case, all these things have come.
Addition, Mihir and
Correct. So here, there may be a situation wherein the arrest has been made. No family member is there at that point of time. So it's not, it's virtually impossible to give take the signature of this. So that's why 48 is there that you can give it. So 48 can be done subsequently also.
Yes.
Before the production.
Yes.
You can give it, or later on also you can give it, because 48 gives two mandates. One is the family member and second is a jurisdictional police officer.
Yes.
These two you'll have to give notice. So jurisdictional police officer, obviously he will not be there. So he has to be given notice subsequently. So and family member also, there was no timeline given at a point of time.
Yes.
So there is no timeline. So it can be given subsequently also. But as far as arrest memo is concerned, there is no timeline has been given. Arrest memo has at the time of the arrest.
Yes.
So at the time of the arrest, you'll have to give. So that means if we read, reasonably, then it means that at the time of the arrest, you'll have, whether you give notice 48 later on, that's a different thing. But at the time of the arrest, one witness has to be there. And that one witness, you'll have to, if family member is not there, a respectful person has to be there. And that is a statutory mandate that has been, with a lot of intention, that has been brought in. Now, whether by saying that 48 I have complied with, so I will not comply with 36, a statutory provision. And 62 also is also there. 62 says that any arrest you make, that has to be as per the provisions of the statute. Now, if you have any problem with the statute, then you'll have to go for the amendment of the statute, nothing else. And interpretation of states, in fact, he has read one case, then another case wherein there is a case called Nasiruddin versus Sitaram Agarwal, 2003 case, okay?
Yes.
There also this, how it has to be read, it has been given. In interpretation of statutes. Yes. Basically, if the statute is, a statute has given certain things to be complied with in a manner, you'll have to do it. Whether it's right, wrong, that's a different thing. Correct. So taking into all these things, what will be your submission on this?
My first submission, Lordship, regarding this point, Lordship, subject to Lordship's correction, this 36C, Lordship, thereby, if we go by the meaning of the literal meaning of this section, Lordship,
subject to correction, Lordship, there is an option given.
Oh.
The option is, Lordship, if Lordship kindly will slowly read, Lordship, inform the person arrested unless the memorandum is attested by a member. So, Lordship, if the memorandum is not signed by a,
So it's a negative thing.
yes, then he has to be.
Negative confirmation has been given.
Yes.
So negative confirmation is more dangerous. So you'll have to comply with.
That's a difficult job for your Lordship to interpret it. But Lordship, I can only make the submission.
No, correct. Please.
Here, Lordship will see option has been given. Thereby, Lordship, if the person is arrested and the memorandum is attested, then the second part will not come. That meaning is there, Lordship. It is apparent. Lordship.
Attested by?
Inform the person arrested. So, if unless the memorandum is attested by a member of his family. So, unless the memorandum is not signed, then the information has to be given to him about his arrest.
So that is an additional term that has been mandated.
Yes.
Correct. But this doesn't take away this section B1.
Yes.
It doesn't take away section B1.
It's in continuation in my respect.
So it's in continuation. Then you see countersign. If you come to B2, B2 said countersigned by the person and. So it's a additional mandate has been given that if the arrest memo is not signed by a family member, then you'll have to intimate him. But if one witness is must.
That again, Lordship, I
And one witness is must. No, you be fair.
Lordship, what I have understood is, Lordship, subject to correction, Lordship, that the option has been given. That either you get one witness attested in the memorandum arrest or you inform by way of 47 or 48. But that's my understanding, Lordship. And Lordship, another thing, Lordship will see that I have already mentioned, Lordship, the NDPS came subsequently. And Lordship 37, Lordship is well aware, Lordship. NDPS case 37 has to be satisfied, no matter what, Lordship. Even if there is a delay, the satisfaction has to be there by your Lordship. That the
NDPS 37, this court has also dealt with. But in many high courts also, other high courts also, they have also dealt with. See 37. See when the the root of the matter. The basic arrest is illegal. Then section 37 may not come into play.
Yes, Lordship. I'm not disputing that. Lordship. That is absolutely correct, Lordship. Absolutely. Whenever there is a delay, fundamental right, prolonged inconsistency, Lordship, I submit to that, Lordship. But Lordship will have to see that when 37 is there and section 6, Lordship will kindly see of the PNSS. I'm sorry, Lordship. Section 5 of PNSS. Savings. Nothing contained in this Sanhita shall, in absence of specific provisions to the contrary, affect any special or local law for the time being in force, or any special jurisdiction or power conferred, or any special form of procedure prescribed by other law for the time being in force. So, Lordship, NDPS being a special statute will prevail over TRPC, Lordship.
But there are cases wherein it says that if NDPS is a special legislation, is correct, but like the provisions of CRPC you cannot avoid. While making an arrest, the provisions of CRPC also has to be complied with. So CRPC has to be complied with means by literally you have to comply with. So if you do not comply with, then it becomes what? Then it becomes an illegal arrest.
Now, Lordship, this few judgments I have collected was the order of this coordinate cases. If Lordship kindly takes up Rafiqul Islam, PA 993. PA 993.
Yes.
Lordship has found it. Lordship will kindly come to paragraph 9. Same issue, Lordship, same issue. A close perusal of the aforesaid section. If this is Lordship 36 has been mentioned. Paragraph 10, Lordship. In other words, a combined reading of the
Yes, this now I have gone through it while writing this.
Then another Lordship I have placed, that is Jabbar Hussain.
Jabbar Hussain.
Yes,
But this while these cases were being decided,
yes,
because this bench has already passed an order.
I'm aware.
But this were not discussed here.
Yes,
Those cases were not placed before this court probably.
before your Lordship.
No, I mean before the coordinate bench when the coordinate bench decided these matters, there are already a judgment on this
No, Lordship.
from this court.
It was placed, Lordship.
Then I don't know. Then if it is placed, then he has come to a different opinion.
Yes, different opinion, Lordship, respectfully. Lordship.
So then we'll do one thing. We will decide this case because I have already heard a matter.
Yeah.
We have already heard a matter,
My lord, I have some more
and
submissions.
that has been already decided.
If Lordship permits me, not sure if Lordship is aware, but this is a judgment of the revision bench of the Calcutta High Court, Lordship's petition. Only paragraph 18. Division bench of Calcutta High Court, Lordship.
In NDPS case,
Yes,
no, that I have seen.
yes, just placing it before you.
Mm. But 18.
Yes, yes.
Mm.
Same issue, Lordship.
Yes, I've seen
Yes,
this.
yes. I'm just placing it for you.
Yes.
One,
No, I have seen this
Yes.
this thing.
one more order of a coordinate bench is there, but I do not have my hands on it. It was passed by the Honorable Justice Midul Kolkar. That is not before me, Lordship.
That is also come to what kind of finding?
In one case, Lordship, in the first case where I have argued, Lordship, Lordship has given bail, Lordship, holding that 36 is mandatory. Subsequently, Lordship, in a case where 48 was complied with, Honorable Justice has dismissed the bail application, stating the same view, Lordship, that if 40 is complied, 36 is not necessary. That order, Lordship, I do not have.
It's fine. It's fine. I am of the view that these are statutory these things, and one more thing is that like only because there is no exception cut out,
Yes.
and 36 is very clear.
Yes.
36 says that attested by at least one witness. One witness has to be there.
Yes.
And if one witness is not a family member, then you'll have to go to C. But without taking any witness, you directly go to the C and say that I have given 48 notice. That may not be compliance. And another thing is, I mean, this bringing of this insertion of these clauses
Yes.
in different times. And when this section 48 was still there, even after the legislature has brought in 36. So intention is not, I mean, it's not that they were not aware of 48. The 48 notice is already there. Then what is the need of like for giving for 36C then? But in spite of that, they have brought in. So this court has a different view. Anyways, I will pass an order. Then let's see. I mean, if you all think that can be referred to a division bench or what that you can think of. But since I have already heard this matter and these cases were not placed before me.
I think Lordship will have to refer it to division.
No, I mean at this time no, because I have already heard that matter and these cases were not placed before me.
One last submission, Lordship, in DK Basu, if you keep the whole judgment, after it states that this guideline should be there, then Lordship, in another paragraph it states that failure to comply with this will lead to departmental action against the police officer.
That should be done.
Yes. And
That should be done.
in that view of the matter, Lordship, because of this custodial there and all this, Lordship, those guidelines was given, Lordship. So, Lordship, it was a procedural
Lapse.
Yes. And the consequences of it is also been stated in the DK Basu case, that it will lead to
Compensation, departmental compensation, all these things.
Yes.
Yes.
It doesn't speak about bail or any other thing.
Yes, see, yeah, you are correct. Like I have also given a lot of thought about this.
Yes.
See, DK Basu case happened in a different context altogether.
Yes, yes.
See, it was about those political
Yes.
arrests. It was about all these like vengeance kind of thing. And I mean, police officers, then custodial thing. You take a person to take to custody, then don't intimate, don't bring it to the magistrate. That's why those guidelines were there. The arrest memo has to be there.
Yes.
There is specifically the identification of the police who has taken it, because so that he can be made personally liable.
Yes.
So all these things were there. That may be in a different context, but since the statute has brought in Now statute has brought in, so, I mean, it is not that state, but legislature hasn't thought about this. Legislature has thought about this. After thinking with their wisdom, they have brought this,
Yes.
this particular section. Now this part, section 36, they have brought in, and section 62, they have, is already there. That specifically says any arrest has to be in compliance with the, with this. Now there is no exception given here. Now, the question comes like whether prejudice, the issue of prejudice, whether issue of prejudice will be applicable or not. And if there is a specific case wherein it can show that, like, I mean, like, prejudice was not there, it was not, I mean, those things are a little bit different. So ultimately, the issue of prejudice has been discussed in the Sridarsan case also. But after that also, Supreme Court has come in, then this, what was the case? Mihir Ranjan has specifically stated that you will have to, I mean, the question of prejudice has been little bit.
Yes. The only
Correct.
thing Lordship will have to decide, it's a difficult job, I understand, Lordship, but that Lordship will have to very much decide, Lordship, that whether this is mandatory or not, whether that optional part, Lordship will have to decide on that only, Lordship. That's the main issue.
No, I have decided it. I have already decided it. I will see, my views is that this taking one witness, there is no exception given. Correct. If there is a, if the person is not your family member, you have a right to be informed. But one witness has to be there. And you can't say that, like, I mean, I have followed this, I have given this thing to one person that will comply, then 36 is totally negated. You cannot negate a statutory provision just like that. The two, I mean, there are legislative intent is there because why they have brought these two sections together? Because see, in arrest time, while arresting, you may not be able to intimate the family member, and that is why one witness is required. Family member is not available, then what is to be done? That he has been arrested, some record has to be there. Then evidence, a witness has to be there that he has been recorded. Then how will you get it? That is the purpose why, that is why the one witness is mandatory. So if you do not have a family member, okay, one option has been given, you take a witness of the witness from the locality. From the locality, you take a witness. Now the police officers are not doing it. I don't know why not doing it, because they have family members, because they have taken signature in the seizure memo, they have taken signature in the section 48 notice, but they have not taken signature in the arrest memo. What stops them? So I will pass an order.
On two specific replies to the learned PP, where the learned PP says that the provisions of the NDPS being a specialized legislation should override. If I may draw my attention to section 51 of the NDPS Act, that specifically says that the procedure of CRPC will apply to arrests. Therefore, that answers the question. The second, the arguments that the learned PP has raised regarding the NDPS Act coming subsequent to the judgment of DK Basu, that all those points have been argued by the learned PP in a bail application which is there before my lords, Amirul Islam, where the Honorable Court of Mr. Justice Mridul Kumar Kolita has specifically discussed those points and negated them. Therefore, that is one relevant order that perhaps my lord would find some assistance in.
No, I mean, like, I have also discussed this. This court has also discussed this, and this court has also said that section 37, if the arrest itself is illegal,
yes,
then there is nothing, then nothing can stop that, save that.
In fact, this order relies on my lord's previous order.
But only problem is that, I mean, the police officers are not performing their duties. So you also take some.
We are bringing it to the attention of the highest officers. That EOP also we have written.
I mean, they should be brought on record. They should be booked.
Especially in this type of cases, it gets very difficult.
So in this case, Mr. Sharma will say that though TCR was not received, on the basis of the materials is as agreed by the people, agreed by the learned council, we have decided to dispose of the matter. Correct? Because since already one similar matter was heard, and I kept it pending only because of this, because I thought maybe something comes up or something different comes up, though I have given a lot of thought and like did some homework, but I'm of the opinion that you cannot negate that. It will be difficult.
Let's hope we have been of some assistance to my lords in this. I hope we have been of some assistance to my lords in this matter.
I have already decided, whatever you are saying, you have done a good job. I mean, you are in the line, because whatever I have, placed there, you are placing those. It is good. Because statute of interpretation also we have brought in another cases also there. They also said if there is no ambiguity, then you can't just like bring in or add in or like give a different interpretation to that. That cannot be done. The interpretation of statute is also very clear about this.
Sorry, Lordship, I was not present in the morning. We missed it, Lordship, to be very honest.
No, it's fine. It's fine. I mean, it is perfectly fine. So only thing is the TCR is not there, but still. So now, I mean, there is no other way. Your police officers has to act, and these are only basic things, very basics, very basics. I mean, there are a couple of days back that the one incident we have been hearing all over the media, what has happened. So that is the thing. Mr. Goswami, police officer को type करना है. Because these are basic things, no? Otherwise, like some complex procedural aspects, they miss out once in a while. That's a different thing. But it's a regular.
This is the ABC laws.
Regular thing. I mean, three things, I mean, like 3-4 things they have to comply with in arrest. So only those things. Anyways, we'll pass an order. Okay. Thank you for all your assistance.
So obliged, my lords, for patient hearing.
Hearing it as a lever, man.
May I please, your lord?
Yes, Mr.
Other day, my lord, petitioner has concluded his submission.
No, yes, basically his argument was that it, I mean, after the cell deed is registered, the registration authority, that is DC,
Yes, my lord.
has become functions of issue,
Functions of issue.
and he cannot cancel it.
Yes.
It can be cancelled only by a civil court,
By civil court.
by way of a cancellation deed.
Absolutely, my lord.
So that is his this issue.
Yes, my lord.
Mm.
Now, if lordship may be pleased to come to the order put to challenge herein, my lord. That lordship will find that, my lord, page 124 of the writ petition. Because the district commissioner has passed 2 orders.
Mm.
This is the order which, my lord, culminates the earlier order, my lord.
Mm.
The earlier order, lordship will find, my lord. My lord, I'm sorry, my lord, the subsequent order, lordship will find at
124 is the initial order.
Yes, initial order. So if I may read it, my lord, with my lord's kind permission. This short order, my lord, I will quickly read it.
Yes, yes.
This matter pertains to an inquiry into the legality of cell deed number so and so, CL number so and so, dated 16/9/22, executed between Srimati Nilima Boisya, wife of so and so, in relation to a plot of land measuring so and so, along with an RCC building constructed on the said land. An inquiry is conducted into the validity of the cell deed, and based on its findings, the present order is passed. Upon examination of the documents submitted and the statutory provisions governing the matter, it has come to light that the cell deed in question is deficient in compliance with essential legal requirements. Section 32 of the GMDA Act 1985 categorically mandates that no deed transferring land within the Gauhati metropolitan area shall be registered
unless an explicit no objection certificate is obtained from GMDA, affirming its approval of such a transaction. However, in the present case, the only NOC submitted dated 25/10/2012 pertains solely to the construction of an RCC building and does not extend to an absolute sale of the underlying land. The absence of a valid NOC for land transfer renders the registration of the deed non-compliant with the GMDA Act 1985, thereby vitiating its legal standing. Further, the sole GMDA NOC dated so and so was granted in favor of Rakesh Boysa for construction purposes only, while the land was at the relevant time legally owned by Nilima Boysa. No duly registered general power of attorney or any other document evidencing authority to sell has been produced to justify the same. Lordship will kindly mark this. Additionally, as per section 21A of the Registration Act, Assam Amendment 2021, no non-testamentary instrument concerning immovable property except for house, flat, residential apartments, commercial building, or any construction or structure erected on a plot of land shall be accepted for registration unless it is accompanied by NOC of the District Commissioner DC. The standard operating procedure by Government of Assam Revenue and Disaster Management Department dated so and so issued under section 21A clarifies that a sale of land requires an occupancy certificate or prior approval from the DC, neither of which have been provided in this case. The absence of this statutory clearance leads to a further legal infirmity, reinforcing the sale deed's non-compliance with the law. The inquiry has found that mutation of the said land was carried out in the name of Sri Rakesh Boysa solely based on sale deed number so and so. As the sale deed itself is legally unsustainable, the mutation carried out on its basis is deemed irregular and may subject to cancellation by the competent revenue authority. Accordingly, based on the inquiry report and legal provisions cited above, the execution and registration of sale deed so and so is found to be legally unsustainable. The deed having been executed in contravention of the mandatory legal provisions is declared invalid for registration and transfer of ownership. Consequently, any mutation carried out on the strength of this deed is rendered irregular and is liable to be cancelled at the discretion of the competent revenue authority. The parties are advised to obtain the necessary NOCs in order to carry out mutation on the same. So, by this order, the district commissioner arrived at the finding that the sale deed concerned was an irregular one. It may not have been a illegal sale deed because the transfer of property between two private individuals is governed under the provisions of the Transfer of Properties Act 1882. He is very clear on that. And the district commissioner being a revenue authority, not being a civil court, he cannot touch upon it. He can only comment that sale deed is irregular. To that extent, having not complied with the statutory provisions of law, more particularly minus section 32 of the GMDA Act, which I will draw minus attention a little later. Now, what has been inculcated in the order, Lordship will kindly see, the parties are concerned are advised to obtain necessary NOCs in order. They were given a leeway. That this is the irregularity for which the mutation could not have happened. Nonetheless, please obtain the NOCs. They do not do it. They are so arrogant that they do not do it. Rather, they file a review petition before the district commissioner. And upon the review petition being filed, yes, that order, Lordship will see, my lord, at page 115. The district commissioner in the order, which at page 124, 125, which just I have read, my lord, says that is a irregular, so please do the
procure the NOC.
Do the needful, get it rectified, and get your mutation. As simple as that, my lord. Then this is the review order. They file a review petition. Finally, it is said, my lord, at page 116. That is the second last paragraph of that order, my lord. Furthermore, the deed does not mention
does mention a no objection certificate obtained from Gauhati Metropolitan. However, it is regarding construction of an RCC building which does not suffice for the purpose of registration. So therefore, they have not obtained any sale permission, either my lord from the district commissioner or which is required under the provisions of section 21A, which was inserted by an Assam amendment, as well as from the GMD authority. So there are two requirements in order to execute a sale deed, and to get that sale deed registered, my lord, if I am the seller or I am the purchaser, both of us has to comply with two statutory provisions. There's a clear mandate. First one is section 21A of the Registration Act. Second is section 32 of the GMDA Act. If I do not comply, so there will be necessarily, my lord, a statutory bar created under the statute, and that bar is not removed, or that embargo is not, my lord, cured without, my lord, obtaining those permissions.
So you're saying that, you're basically saying that it is not cancelled.
It is not
It
cancelled.
is not cancelled, but it was found irregular.
Irregular.
And an opportunity has been given to the petitioner that
Correctly.
you bring an NOC and and then defect can be rectified and it can be mutated.
Absolutely.
So basically the mutation is denied because of an irregular sale deed.
Yes. Now,
That is
why it has been done so? District Commissioner is a revenue authority. Revenue authority is a settled position of law, my lord, even by this honorable court, as well as there are catena of decisions by the honorable apex court. I need not go to that. The revenue authority does not have any jurisdiction whatsoever, even to touch a sale deed and to declare it, my lord, illegal or void ab initio, whatever it is. But the revenue, it is for the competent civil court to pass such a declaratory decree if any of the parties wishes to, my lord, move a suit in that regard. But the revenue authority, being the custodian of all the revenue records, has a clear jurisdiction under the law to make any rectification, my lord, with regard to the revenue entries in the record of right. Mutation is nothing but a revenue entry in the record of right. Record of right in the common parlance, we say it, my lord, Samabandi. So once a mutation is done, it means, my lord, the land has been settled. It is settlement of land. Now, once it is thereafter, if it is found by the concerned authority that the land was settled or mutated, they hold the statutory provisions of law, and there was apparent and material irregularity, he has the power to cancel. How he has the power to cancel, that I will satisfy, my lord. Now, lordship will kindly, my lord, see the sale deed. What is sought to be transferred? That lordship will find, my lord, at page 74. Here, the
sale deed starts from page
yes, sale deed starts from page
66.
66, my lord.
Mm.
Yes, I'm so obliged, my lord.
Mm.
Sale deed starts from page 66.
Mm.
Nilima Boiso is the seller,
Mm.
and Nilima Boiso is the writ petitioner in the present writ petition.
Mm.
She is the seller.
She is the
And
seller.
to whom it is sought to be sold? My lord, Rakesh Boiso.
Mm. The son.
Yes,
One of the son.
yes.
Mm.
Whosoever it is, my lord.
Mm.
It is sought to be sold to one Mr. Rakesh Boiso.
Mm.
Now, what is sought to be sold? That lordship will find at the schedule, which is mentioned, my lord, described in page 74. Kindly see, page 74, my lord.
Mm.
Lordship will kindly mark this. A plot of land, a plot of land measuring 3 kothas, 0.58 lessers covered by so and so, with RCC building, ground floor, standing there, measuring 170.85 square feet in the ground floor. So what is, my lord, what is purported to have been sold by the strength of the sale deed is, my lord, two properties, two immovable properties.
One is the land and the
land.
RCC building.
Absolutely, I'm so obliged. Now, my lord, in the year 2009, this Registration Act came to be amended, and thereby, my lord,
2000?
2009,
2009 registration act amended.
amended by virtue of, my lord, Assam Amendment. Assam Amendment, thereby incorporating one provision, that is, my lord, the provisions of section 21A. Section 21A in the Registration Act. That is the Assam Amendment.
Hmm.
Now, by virtue of Section 21A,
Hmm.
if any immovable property is sought to be sold by any person, he can sell it, my lord, no difficulty. Sale can be interstate between any two citizens of India.
So he need to take a permission from the DC.
DC. And if the DC does not grant permission, of course, he will have to lay an application before the district commissioner. On laying of that application, if no order is passed within, my lord, 30 days, then it will be deemed, my lord, that sale permission has been granted. Otherwise, if the district commissioner sought to reject, my lord, that sale permission, he will have to give reasons. These two are the primary conditions incorporated in Section 21A. In the year 2022, this Section 21A came to be amended.
Correct.
And my lord, relaxation was given with regard to transfer of immovable properties other than land. Meaning thereby, my lord, if I own a flat, I can sell my flat
Without permission.
without obtaining any permission from the district commissioner, my lord, in compliance of Section 21A. But if I have to sell any land, I will have to, my lord, take permission. So far as sale of land is concerned,
That is still there.
that is still there, right from insertion of 21A till, my lord, till date, even as on today. Here is a case of the petitioner, which is squarely governed by 21A. He have not denied it. 21A is squarely covered. So under 21A, the seller, that is Nilema Boysa, is required to obtain a sale permission, my lord, NOC, from the district commissioner, because land, I could have perceived the situation if only the house has been sold or a flat has been sold. But here, along with the land, the house is sold. So land, my lord, land issue is still intact. So therefore, they will have to obtain a permission. They haven't obtained that permission, number one. Number two, in pursuance of, my lord,
And she is the owner of 3 kothas and 58 lessas.
yes, there is no denying this.
And the whole land is sold.
Yes, 3 kothas, 0.58 lesser.
So the whole land is sold, right? Not part of it or something like that.
Appears
A
that
plot
both-
of land measuring so and so, covered by so and so,
even
standing in the
itself-
standing and measuring. Immense square ground floor. Yes, the whole land is.
Now, for the time being, if we keep aside, my lord, that aspect of the matter, whether part or wholesale, admitted position on the face of the record is that, my lord, land is sought to be sold. Land is sought to be now sell out. Now, if I want to sell out
You know
my
what?
land,
No, now what happens? I mean, now a flat or a house
Yes.
which is standing on the land. So I mean, you cannot sell only the this thing, the flat or because proportionate for
proportionate
land and house also, like that house whereon actually this
yes,
I mean house is standing, the land that has to go with that.
to go.
So
That's fair.
in that case, what happens?
In that case also, my lord, my lord, that relaxation comes into play. The authorities take it, my lord, in this way, my lord, that if a flat is sold to be whole, that proportionate land also goes with the flat.
Goes with the thing.
Yes, it is not taken to be an independent component.
Mm.
Now, here is a case where land is an independent component. House is standing there alone. It is not discernible from the pleadings or from the statements made in the.
So he hasn't built a house on all over three kotha land.
Yes.
He's built a house, only a small house, maybe a house, a portion of the portion
Whatever it is,
portion on the land.
Yes. But the land is now sought to be sold along with the house. It is not other way around. That the house along with the land. It is not the house along with the land. It is a land along with the house.
3 kotha.
Yes. It is, my lord, undiscernible that a person will, my lord, construct a house about 3 kotha. It is, my lord, large, almost, my lord, a go down like, my lord, structure. Now, after having, my lord, this sale deed rightly, wrongfully being executed.
It was executed, yes. That is the point now, yes.
It is registered. Then, my lord, the authority makes a entry in the revenue records. That lordship will find at page 99. Page 99 onwards, my lord.
Yes.
Page 29, if Lordship may be pleased to come to page 102, my lord. 102.
Yes.
102 on the right hand side, my lord, in the Mottoi remarks column, my lord.
Hmm.
Because this is the certified Jamabandi copy.
Hmm.
It's a public record, my lord. We are not denying it. My lord, Lordship will see at the extreme right hand side, my lord. The first para, my lord, if I may read it, my lord.
Yes.
হুকুম চক্ৰ বিষয়াৰ 10-11-22 নামজাৰি হুকুম মতে খৰিদাৰী দখল 3.58 লেচা খৰিদাৰী দখল সূত্ৰে নীলিমা বৈশ্যৰ স্থলত শ্ৰী ৰাকেশ বৈশ্যৰ নামত নামজাৰি কৰা হ'ল। So that means that land.
The whole land has been
Yes.
three katha and 58
Yes,
lesa.
the whole land, whole land. No denial to that fact, no quarrel. My lord, so the name of the seller has been struck out, that is Nilima Boissa has been struck out, and the name of Rakesh Boissa has been mutated, meaning thereby that Rakesh Boissa, the land is now settled with Rakesh Boissa, and he becomes the pattada. He becomes the pattada. Therefore, Lordship will see on the extreme left-hand column, my lord, in the third column, my lord, that it appears Srimati Nilima Boissa. Now, thereafter, Lordship will kindly see, my lord, again come to the right-hand side and in the remark column, Mottobya column, the second sub-paragraph, my lord, if I may read it, Kamrup Jila Ayukta Mohadoyo, 27/8/2024 চিঠি হুকুম মৰ্মে ইমান তাৰিখৰ ইমান ৰেজিষ্ট্ৰি দলিল কমিক মতে বেলতলা মৌজাৰ বৰসজাই গাঁৱত খেৰাজ ম্যাদী ইমান নম্বৰ ডাঙৰ ইমান নম্বৰ পট্টা 3.58 লেচা জমিত বিক্ৰীদাৰ নীলিমা বৈশ্যৰ স্থলত ক্ৰেতা শ্ৰী ৰাকেশ বৈশ্যৰ নামত হোৱা নামজাৰি কৰ্তন কৰাৰ হুকুম হয়। So his name has been deleted by virtue of this order, my lord, which is put to challenge. আৰু হুকুম মতে নথি সংশোধন কৰা হ'ল। Now, again, my lord, back to square one. So Nilima Boissa's name has been restored, and they were given, my lord, granted an opportunity that you correct it, you obtain the sale permission. Who is denied? Nobody is denied. It is nobody's case that they are prevented from selling the land. She can very well sell them, but please obtain the necessary permission, which is required under the statute. So 21A, it has to be. Now coming to the provisions of, my lord, the GMDA Act, let us see, my lord, the GMDA Act. GMDA Act, my lord, 1985, section 32. Section 32. So there are basically two embargoes at this moment, my lord. One, under the provisions of section 21A of the Assam Amendment Registration Act, and the second one is, my lord, 32. 32 appears to be more stringent. If I may read 32, my lord.
Yes.
And so, like, prohibition of registration in certain cases where any deed or document required to be registered under the Indian Registration Act 1908 purports to subdivide any land or transfer any land within the Gauhati metropolitan area. No registering officer shall register any such document unless the party presenting the deed or document for registration produces a no objection certificate from the authority to the effect that the authority has no objection to the registration of such deed or document. So there is a clear mandate. It is akin to the provisions of, my lord, 21A. I am clear, my lord, I hope.
No, till now you are clear.
Yes, I'm so obliged, my lord. Now, the challenge that has been laid by the petitioner here that this district commissioner do not have the jurisdiction to cancel settlement. Who can say once settlement is granted? No, you cannot.
He's challenging the settlement or he's challenging the cancellation of the deed?
Cancellation of the deed, my lord. Deed has not been cancelled. Let us be clear.
That's what, now what is his challenge here?
Yes, he challenged that. Therefore, if lordship comes to the prayer portion, my lord, at page, my lord, page 25. Page 25, my lord.
Yes.
He is paying for a writ of certiorari. read in the nature of certiorari to set aside and quash the order dated 27/8/24 and 17/12/24, which Lordship has just now seen.
So 27/8/24, these two orders of the DC.
Absolutely,
Hmm.
absolutely. I'm
Hmm.
so obliged. Then,
Hmm.
read in the nature of mandamus not be so directing to restore the name of the petitioner in the land record. This is right. To restore the land of the petitioner. And after return of the rule, these are my lord, then my lord, the interim prayer is my lord praying for a stay of that order. Now he is basically on settlement. He is basically on settlement. Now, the tenor of the writ petition, now my lord, section 21A has been, my lord, reproduced at paragraph 15. So I did not trouble your lordship with the provisions of section 21A.
21, I have seen this.
Yes, and then my lord, so far as section 32 lordship has seen, my lord, there are two clear embargoes. So he is now seeking, my lord, a prayer before the honorable court to set aside and quash these two orders, and number two, for restoration of the settlement. So therefore, a question arises, issue arises, whether the district commissioner has the jurisdiction to cancel the settlement. Now, settlement has, in my lord, as such, my lord, settlement as such has not been cancelled. What has been directed in the order, let us see, my lord, the first order again, they were given, my lord, a leeway, granted an opportunity, you get it, my lord. Now, in pursuance of that, my lord, the review petition has been, my lord, laid before the district commissioner. District commissioner rejects the review petition, and thereafter, my lord, the mediation entry settlement has been cancelled. Now, settlement has been cancelled. Let us take it.
So where is the power of, is there any power?
Absolutely,
No,
absolutely.
power.
Now it is his case, my lord.
No, his case is, he's cited a Supreme Court case also. He's saying that once registration has been done, so it follows a lot of civil consequences out of that.
Yes.
So sale deed means you're selling a property, immovable property, whatever. Immovable property has been sold,
Yes.
and it can be done by way of one of the ways to by a sale deed.
Yes.
So now sale deed has been registered.
Yes.
Now DC does not have any power once it is registered.
Yes, ma'am.
DC doesn't have any power to cancel it. That is his case.
Yes.
But in this case, you are saying that sale deed has not been cancelled. It has been declared irregular because of deficiencies in providing certain relevant documents.
Non-compliance of the statutory provisions.
Yes, and an opportunity has been also given to him that he procure this, but that has not been done.
Since he has not done it, so consequently settlement has been, my lord, cancelled.
Cancelled.
Now it is a part of the Jamapandi land record, my lord.
Mm.
So at one point of time, he had attained the status of a pattadar, then again it reverts back.
Correct.
He loses his status of a pattadar. It is as simple as that. Now, whether the district commissioner has the power to do so, this is precisely to be examined here, my lord.
Correct.
For that purpose, my lord, I am relying on two decisions. If Lordship may be pleased to see it.
Yes.
The basic, my lord, authority is to be found, my lord, in section 21 of the General Clauses Act.
Section 21 of the General Clauses.
General Clauses Act, which is perimeteria with section 23 of the Assam General Clauses Act.
Which is perimeter to what? Which clause?
It is perimeteria to, my lord, section 23 of the Assam General Clauses Act 1915. 1915. And the Central General Clauses Act, my lord, that is section 21. It is, my lord, General Clauses Act 1897. That is a law, my lord, laid down by the, my lord, Parliament at that point of time.
And Assam came into when
1915.
15.
Yes, 15, my lord.
15.
So
yes.
here there will be two provisions. Section 21 of the General Clauses Act 1897.
There is Central Act.
Yes, that is the Central Act. And the perimeteria provision, my lord, section 23 of the Assam General Clauses Act 1915.
So Assam is there. So Assam has adopted that almost. So section 23 will be the guiding.
Now for a moment, if Lordship takes up, my lord, the decision of the full banks, my lord, in IA, that is Atwar Rahman. If Lordship may be pleased to
Yes,
take up
yes.
the Atwar Rahman.
Atawar Rahman.
Yes, Atwar Rahman, Lordship will kindly see, my lord. It is a, my lord, full bench decision of this honorable court. In that matter, what had happened, my lord, it was referred to the full bench because of this issue. Well, here the facts were such, my lord, there was a society which was, my lord, the register of societies granted permission and the society was registered. At one point of time, well, I 1500 What did it come? Now a society was registered under the provisions of Societies Registration Act, and my lord, there was no provision in the Society Registration Act empowering the register of societies to cancel such my lord registration. But he had cancelled it. It was put to challenge. There were contradictory judgments, my lord, of the honorable court. Matter was referred to the full bench. The full bench had relied on the provisions of section 21 and 23. Stating that if I have the power to grant, I also have the power to revoke. It is inherent.
That principle has been applied.
Yes, and that principle has been fortified by the Honorable Appeals Court in Sidbali Steel's decision. That is also a part of the this decision. I will draw my lord's attention. If now Lordship is taking up that judgment, my lord, Lordship will kindly see, my lord, paragraph 1. Paragraph 1.
Yes.
Two questions of law have been reversed by a single bench of this court for a decision by a larger bench. The matter is placed before this full bench, although the same could have been answered by a division bench of this court. Be that as it may, the two questions are whether registration of a society by the Register of Firms and Societies Assam under Section 3 of the Societies Registration Act 1860 cannot be cancelled once registered, and whether the decision in Sodo from Puthi Prakashok or Bikreta Sangha and another, so this was the contradictory decision.
Correct.
Now, Lordship will kindly see, my lord, paragraph 4. Paragraph 4.
Yes.
Paragraph 4, my lord, the provisions of section 21 and 23 has been, my lord, reproduced. Lordship will kindly see the next page, my lord, page number 6, my lord.
Yes.
Page number 6, my lordship will kindly see, my lord, section 21, if I may read it, my lord.
Yes.
Section 21 of the General Process Act 1897, power to issue, to include, power to add to, amend, vary, or rescind notification, orders, rules, or bylaws. Lordship will kindly mark these orders, any order passed, where by any central act or regulations, a power to issue notification, orders, rules, or bylaws is conferred, then the power includes a power exercisable in the like manner and subject to the like sanction and conditions, if any, to add to, amend, vary, or rescind any notifications, orders, rules, or bylaws so issued. Then section 23, power to make include power to add to, amend, vary, or rescind orders, rules, or bylaws, where by any act a power to make or issue notifications, orders, schemes, rules, forms, or bylaws is conferred, then that power includes a power exercisable in the like manner and subject to the like sanction and conditions, if any, to add to, amend, vary, or rescind any notification, orders, schemes, rules, forms, or bylaws so made. Now, Lordship will kindly come to, my lord, paragraph 11. In between, my lord, the submissions made by the rival councils have been, my lord, discussed. Now, Sidbali, my lord, paragraph 11, Sidbali has been, my lord, discussed. Sidbali, Lordship will find a reference at para 7, my lord. Prior to that, my lord, Lordship, I'm sorry, my lord, I'm troubling my lord.
No issues. No issues.
Paragraph 7. Yes, paragraph 7, my lord. Paragraph 7. A handful of decisions are placed for consideration by Mr. Secretary in support of his argument. We have gone through the same and make reference only to those case laws in our considered view having bearing in the adjudication so and so. At serial number Roman 2, Lordship will kindly mark, my lord. Sri Sidbali Steels Limited and others versus State of Uttar Pradesh and others. Reported in 2011 3 SCC 193. 2011 3 SCC 193.
Mm.
Now, Lordship will kindly see, my lord, paragraph 11. The citation of Sidbali has been, my lord, stated. Now, what is Sidbali?
Mm.
In Sidbali Steels, paragraph 11, my lord. In
Yes.
Sidbali Steels Limited, Supra, the Supreme Court explained that Section 21 of the General Clauses Act, which is of general application, is based on the principle that where there is power to create, it includes the power to destroy, as well as the power to add to, amend, vary, or rescind. Where there is a power conferred on any authority to do a particular act, such power carries with it the power to withdraw, modify, amend, or cancel the act, which is exercisable in the like manner and subject to like conditions, if any, attached with the exercise of the power. Now, in Assam, under the provisions of Assam Land and Revenue Regulation 1886, it is the collector who grants settlement, meaning thereby collector means the district commissioner. So if the district commissioner has the power under the regulation to grant settlement, which has been done in the instant case at a prior point of time, he necessarily has the power under the provisions of Section 21, Review 23 of the Assam Act to cancel it. This is precisely my argument. And which was also done, my lord, in case of registration of societies under the provisions of Society Registration Act. There was no provision under the Society Registration Act to cancel a society which has been registered. But the registrar went and cancelled it. This was put to silence. Now, paragraph 17, my lord. What is the decision of the bench, my lord? Yes, full court. To sum up, we hold as follows. An order of cancellation of certificate of registration that had been granted under Section 3 of the Societies Registration Act 1860 is an order within the meaning of orders under Section 21 of the General Clauses Act and that of Section 23 of the Assam General Clauses Act. An order of cancellation of certificate of registration by the Registrar of Societies is neither a legislative nor a quasi-judicial order, but purely an administrative order. An order of the Registrar, next page, my lord, Roman 3, an order of the Registrar of Societies cancelling a certificate of registration on a complaint and after giving opportunity of hearing to the contending parties is an act of expediency and not a quasi-judicial act dictated by rules. Here also in the instant case, they have filed review, they were given ample opportunity, they were given the right of hearing. It is not their case, my lord, that the rule of audio time per time has been violated explicitly. No, not at all. They were even asked, given an opportunity, please do the needful, please rectify. You get your salary rectified and get it done. Your mediation would get restored. They have not, my lord, acted on the direction issued by the district commissioner. Then one of the provisions of Section 21 of the General Clauses Act and or Section 23 of the Assam General Clauses Act, in the absence of an express power of cancellation of certificate of registration under the Societies Registration Act, is available, empowering the registrar to order cancellation as above. So he has the power. Similarly, the district commissioner has the power under the regulation to grant settlement, taking import of the provisions of Section 21 and 23, read with this full bench decision that district commissioner also necessarily has the implied power to cancel mutation, registration in fact. So this is precisely have been done. Then paragraph 18, for all the foregoing reasons, we answer the reference by holding that a society registered by the Registrar of Firms and Societies under Section 3 of the Societies Registration Act 1860 can be cancelled by such registrar after registration and after affording opportunity of hearing to the party who may be affected. The decision in Sodova from Putina, that has been, my lord, sought to be negated. Now, one another decision which I have laid before my lord, that lordship is that Purbuto with the handicap.
Yes.
That is, my lord, judgment and order dated. Okay. Then, my lord, The judgment and order dated, my lord, 5/2/2024, my lord, passed in WPC 2321. Here also, my lord, a similar situation error. Here, what has happened, my lord? My lord, in the Fancy Bazaar area of Gauhati city, near the old jail, there was a plot of land which was settled by the government of Assam in favor of a cooperative society. That is, my lord, this Purvutto Widow Handicraft Cooperative Societies Limited. My lord, on the ground that this part and parcel of it was a large piece of land, my lord. It was settled that they will construct, my lord, building therein, which will be beneficial for the weaving community, weavers, and they will hold up a showroom, and they will have workshops, they will have their machineries and factories, mini factories, everything. Under that condition, it was settled. What had happened thereafter? They did not, my lord, make use of the land in that manner. Rather, they handed over that plot of land to a builder, and that for the purpose of, my lord, construction of multi-story building. And out of that construction, my lord, they sought some money. As if I am the landowner, I get some money, and in return, my lord, I get some flats. But this was done. Now, when the matter went to the government settled the cancellation. That was put to challenge here. Similarly, my lord, there also that question arose, my lord, in this writ proceedings, my lord, that whether if the government has the power to grant settlement, whether the government has the power to, my lord,
Cancel it or not.
cancel it. There also, my lord, similar line of argument was raised by both the parties. If Lordship may be pleased to come to, my lord, paragraph 51. It's a long judgment, my lord. Paragraph 51.
Yes.
Paragraph 51, my lord.
Yes.
I may read it, my lord.
Yes, yes.
And so obliged. The third point for determination is as to whether the authority concerned has the jurisdiction to pass the impugned order and whether the impugned order was justified in the facts of the present case. The above discussions already made clearly shows that the petitioner herein had obtained the settlement from the respondent authorities by playing fraud and by misrepresenting the state government. And as such, this court had categorically held that there was no acquisition of right under Article 300A of the Constitution. In order to decide as such whether the respondents had jurisdiction to cancel the said settlement, it is the opinion of this court that Section 23 of the Assam General Clauses Act 1950, which is perimeterial to Section 21 of the General Clauses Act 1897, would be applicable. It is a tried principle of law that if a power is conferred to create, it includes the power to destroy and also the power to alter what is created. This is the principle upon which Section 23 of the Assam General Clauses Act 1915 is based. In that regard, this court finds it relevant to refer to the judgment of the Supreme Court in the case of Sri Sidbali Steels Limited versus so-and-so 2011 3 SCC 193, paragraph 38 and paragraph 39, my lord.
Yes.
The purpose, import, and consequences of Section 21 has been, my lord, laid down. I did not read it, my lord.
Yes,
Lordship
yes.
has seen it. Now, Lordship will kindly see paragraph 52. In view of the above proposition and the same being applied to the facts of the instant case, it would be seen that as the government had the power to grant the settlement, the government also had the power to cancel the same. If the settlement is not obtained, is not in accordance with law. Lordship will kindly mark this. If the settlement obtained is not in accordance with law. This is my lord precise submission at this stage. So therefore, the petitioner may, my lord, get his sale deed regularized by obtaining the permissions, which is not at all, my lord, a Herculean task. He can very well do it. Thousands of citizens every day across the state of Assam are doing it, my lord.
But have you gone through this Satyapal Anand case? What he was referring to is the other day.
Satyapal Anand's case is on a different context.
No, what is the context? Let us see.
Yes.
Which para you refer to?
Lordship, I have referred the paragraph. Paragraph 21, their issue.
Paragraph?
Paragraph 13 is the Lordship issue, and the issue has been decided under paragraph 21. And your Lordship, and paragraph 25, Honorable Supreme Court has said that who is the 26 Lordship, who is the competent authority?
Now let us see what is there, what was there in the case and what is. You have a copy, then you give it to him.
Yes, my lord, I have it, my lord.
Yes, paragraph, you said issue is where, paragraph?
Issue is paragraph 13, your Lordship will find the.
Paragraph 30,
13, 1 3.
1 3.
On the next page, your Lordship will
One
find.
second, 1 second. Let us go to the 13 first.
Yes,
What, go one by one. Paragraph 13. Paragraph 13, yes. D and E.
D and E.
Whether sub-register has, read.
Now, whether the sub-register registration has authority to cancel the registration of any document, including an extinguishment deed after it is registered. Similarly, whether the Inspector General registration can cancel the registration of extinguishment deed in exercise of power under Section 69 of the Act 1908. And the second issue has been decided by the Honorable Supreme Court, whether the sub-register registration had no authority to register the extinguishment deed dated 9th August 2001, unilaterally presented by the respondent society for registration. Now your Lordship will find paragraph 21, Honorable Supreme Court has under the paragraph 20 and 21 has discussed the issues. And
but in this case, there is, I mean, there was an extinguishment deed also which has been presented before the sub-register.
Correct.
Correct. Extinguishment, there was an agreement.
Agreement.
Then agreement was registered.
Yes.
Then one party or somebody came saying that this agreement or deed should be extinguished. So whether in that situation extinguishment deed can be registered, can be registered or not?
Can
Because
it be recalled?
No, because extinguishment deed means the other agreement has gone.
Yes.
Correct.
Yeah.
So you are extinguishing the earlier deed.
While discussing these points, your Lordship will find under paragraph 21.
Paragraph
the rule
21.
of Lordship sub-register that has been discussed, and this judgment has been following by the Honorable Supreme Court in the present in a judgment passed on 26 Lordship 22 January 2026. Honorable Supreme Court has referred.
Okay.
The role of sub-register registration stands discharged once the document is registered. Raja Muhammad Amir Ahmed Khan Supra, Section 17 of the Act 1908 deals with the document which required compulsory registration. Extinguishment this is one of such document referred to Section 17(1)(b). Lordship, my registration has also been made under Section 17. And Section 18 of the same Act deal with documents registration whereof is optional. Section 20 of the Act deal with document containing interlineations, blanks, erasures, or alterations. Section 21 provide for description of property and maps or plans, and Section 22 deals with the description of house and land by reference to government map and survey. There is no express provision in the Act of 1908 which empowers the register to recall such registration. The fact whether the document was properly presented for registration cannot be reopened by the register after its registration. The power to cancel registration is a substantive matter. In absence of any express provision in that behalf, it is not open to assume that the sub-register of registration would be competent to cancel the registration of the document in question. Similarly, the power of Inspector General is limited to do superintendence of registration offices and makes rules in that behalf. Even the Inspector General has no power to cancel registration of any document which has already been registered. Now, your Lordship may kindly come to paragraph 25. may I read, Lordship, the refer, at the same time, Your Lordship, I think, at the same time,
You are reading from where?
Lordship, section, section.
Now, Andhra Pradesh High Court, then you're referring to 25, right?
25, yes, Your Lordship.
The Andhra Pradesh High Court in the case of Yanala Maleshwari.
Yes, was called upon to consider whether a person can nullify the sale by executing and registering a cancellation deed, and whether the registering officer like district registrar and or sub registrar appointed by the state government is bound to refuse registration when a cancellation deed is presented. The fact remains that if the stipulation contains in section 17 and 18 of the Act 1908 are fulfilled, the registering authority is bound to register the document. The registering officer can refuse to register a document only in situation mentioned in sections such as 19 to 22, 32 and 35. At the same time, once the document is registered, it is not often to the registering authority to cancel that registration, even if his attention is invited to some irregularity committed during the registration of document. The aggrieved party can challenge the registration and validity of the document before the civil court. And now Your Lordship may kindly refer one judgment recently passed by the Honorable Supreme Court in the case of Hemalata versus Tukaram. It is already in record, Lordship, because it is very recent judgment, Lordship. It's passed on 22nd January 2026.
Yes, paragraph
31. Hemalata.
Yes.
May I read, Lordship? Paragraph 31. It is a settled position of law that a registered sale deed carries with it a formidability, presumption of validity and genuineness. Registration is not a mere procedural formality, but a solemn act that imparts high degree of sanctity to the document. Consequently, a court must not lightly or casually declare a registered instrument as a sham, adopting the principle enunciated in these are the judgment relied. This honorable court reiterated that the burden of proof to displace this presumption rests heavily upon the challenger. Such a challenge can only be sustained if the party provides material particulars and cogent evidence to demonstrate that this deed was never intended to operate as a bona fide transfer of title. The 32. The ground typically accepted to challenge a registered deed at the instance of the vendee executant are fraud or want of capacity in any party or mistake of fact or fundamentally illegality, like where the deed was executed under deceit or sold.
So some exception has been carved out.
Lordship?
Some exception has been carved out.
No, Lordship, the remaining part is there, Lordship.
Read.
Where it was executed under the settlement was who did not own the land or where the deed was executed without consideration. Namely, if no money or value was actually exchanged despite recital in the deeds, and where there was a coercion or intimidation, like where the seller was forced to sign without free consent. While the aforementioned grounds are illustrative and not exhaustive, this court must caution against the growing tendency to challenge registered instrument at the drop of a hat. If the sanctity of registered document is diluted, it would erode public confidence in property transaction and jeopardize the security of title. In a society governed by the rule of law, registered document must inspire certainty. They cannot be rendered precarious by frivolous litigation. And this
does not provide for any straight cut ratio. It gives some exceptions. in certain
It is
circumstances.
in the civil court, Lordship. Civil, this is the decision out of a judgment from the civil court, Lordship.
Hmm.
Civil court has decided, not Lordship by the revenue officer. The civil court has decided, then also Supreme Court has said that no, this kind of once the registration has made under the Registration Act, then there must be some. It must be presumed that it is Lordship.
No, correct, but then they say ki there are some certain exceptions, and let list is only illustrative, not exhaustive.
If there is any exception, let them.
Yeah, so in this case there is an exception. They are saying that these are the problems.
That authority has been Lordship.
No, that's why I'm asking. No, correct. No. Now in this case, the other case, yes, there was some positive remarks that like it cannot be touched. But where in this case nothing has been stated like that.
Yes, this is Lordship another one that registered document, that is genuinity of the confidence and the registration, that is Lordship. Therefore, I have relied.
It says that courts should not take it lightly.
Lordship,
In declaring something, I mean,
Yes.
Once it is registered, you should not take it lightly.
Lordship may kindly take up the judgment pass Asset Reconstruction Company, para 53.
Asset reconstruction.
Yes, Your Lordship.
Yes, para.
Your Lordship may kindly come to para 57 first.
Yes.
In suit for declaration of title and or suit for declaration that the registered document is null and void, all the aforesaid three steps which comprises the entire process of execution and registration come under challenge. If a party question the very execution of the document or the right and title of a person to execute a document and present it for registration, his remedy will only be to go to the civil court. This is the judgment of 2022, Lord.
See, here's read the next line.
Lordship. But where a party question only the failure of the registration authority to perform his statutory duties in the course of the third step, it cannot be said that the jurisdiction of High Court under Article 2026 stands completely ousted. They have not challenged here, Lordship. And ousted. This is
No,
for
you
the
have
reason that
you have come to the court. The court has noticed now certain things.
Lordship,
See, you have challenged two orders, right? Saying that those two orders are in violation.
yes. Lordship,
So that has come to this court. So courts this thing.
but the reply of the Learned Counsel for the Lordship Revenue Department, Lordship, I would like to reply in two parts, Lordship. One part is that he must be first ascertain which order he would like to rely, whether there is any retrospective or prospective effect in the amendment laid by the brought by the legislation. If there was any retrospective effect on the office memorandum which was passed by virtue of the subsequent amendment, which was office memorandum was issued on 6/12/2022. It nowhere mentioned that there is any retrospective effect. Nowhere mentioned. If he will supporting that.
No, he's arguing on 2009 Act.
No, Lordship, 2009 Act has already gone.
2009
has already gone.
No, 2009 has been replaced by 2022.
22.
22 has given certain exceptions. Exceptions means that but 2009 was there all throughout.
Not there.
Right. 2009, as per 2009, if you want to go for a sale,
yes, sir,
for a house also, then you'll have to take the permission. But 2022 has relaxed it, saying that if you want to sell a house, NOC is not required.
Part is covered.
No, covered.
Which is,
but now what is your argument? What you are saying? Your sale deed was executed when?
Executed on 16th and 2022. And at that time, that amendment was in force.
Which force amendment?
The 2022 amendment.
Correct. 2022 amendment, but only for house. But your thing is the land.
Lordship, if that part your Lordship will accept the submission of the Learned Counsel for the state respondent, then the Deputy Commissioner is absolutely wrong in the pass in the review order.
Why?
He admitted that his power has been negated.
His power has been negated for what?
To issue this sale permission, NOC. He has admitted.
See, where is that?
It is there, Lordship.
Then,
No, he has said it that negated for transfer of residences.
no, Lordship, he has not.
Not for this thing,
In my case, he has stated, Lordship.
in your case, but what
In
kind of, what kind
115,
of?
your Lordship will find.
Hmm.
Yes, third paragraph. When the requirement of the permission,
115, third paragraph, while the requirement.
while the requirement of the permission of the deputy commissioner may be negated
Hmm.
by the aforesaid law, section.
Which aforesaid law?
The amendment that was brought under the Registration Assam Amendment Act 2022, which is applicable to my case.
Correct, no, then read.
And if it is applicable, if that law is applicable,
No, he's saying that while the requirement of permission, deputy commissioner may be negated by the aforementioned law.
Yes.
So he's saying about what? The
He's
the
saying
operative law, the operative law, when the sale deed was signed 21A of the registration act so and so, prior to its subsequent amendment, was that non-testimony evidence so and so shall be accepted for registration, so and so, no objection certificate containing also no objection, such other no objection certificate which are required to be issued by deputy commissioner or any other authority under the law for time being enforced, or any other executive instruction so and so so and so. While the requirement of the permission of the deputy commissioner is negated by law, the 32 of the Gauhati Municipal Development Code Conformity Act provides that whenever a deed purports to transfer any land, so he's referring to by this 32.
32, but he referring 32 is applicable only in the case of 2009 amendment. That is his own observation. Your Lordship will find it.
No, he's saying 32 is still there.
Your Lordship may kindly.
Then 32 is an act of 1972.
Your Lordship may kindly come to the last observation which has been made to pass this order.
Okay, last week.
Section 32 of the Gauhati Metropolitan Development Authority Act 1972 provides that whenever a deed purports to transfer any land within the Gauhati metropolitan area, such deed may only be registered if there is a no objection certificate from the Gauhati Metropolitan Development Authority to the effect that the authority has no objection to the registration of such deed or document. Gauhati Metropolitan Development Authority Act 1985, being a special law passed solely to govern development issues of Gauhati metropolitan area, must prevail over the general law on the registration section 21 of the Assam Registration Amendment Act 2009. He relied on the section 29. At that time it is required, Lordship.
But 32 is still there.
No, Lordship. 32, if your Lordship will go by the entire Lordship amendment, then it is very much clear, Lordship, except if it is included, Deputy Commissioner.
No. Okay, he may have written that 2009
yes,
has been negated by 2022. Okay.
Yes.
Correct. But he at the same time he said that section 32 is still there. It's a special act.
He says, Lordship, section 32 is there on the strength of 2009 amendment. He relied this one.
How can these two acts are two texts? No, he's not saying so.
This is why, Lordship.
How he says so?
Yeah, it is your last part, section 20 of the Registration Act. It is must prevail over the general law on the registration.
Correct. He's saying that like if section 21A is also not there, if it is there, not there, he's saying that if they are not there, forget about this.
Yes.
But 32 is there. The 32 is prevail over section 21A. That's what he's saying. And 32 is already prevalent at that point of time.
Lordship, 32 is prevalent, but he relied on the office memorandum dated 6/12/2022.
Correct, understood.
That is not applicable in my case.
No, that's why he said in a review order. That's why he said that 22 maybe that 22 is applicable or not applicable. That's a different thing. But 32 is still there. That is sum and substance.
If your Lordship will find his another observation made in under page number 125 in the previous order. Here he relied to pass the entire decision on the basis of the office memorandum 6/12/2022.
Understood. So he realized the mistake. Maybe he understood that there was he understood that there was an amendment happened.
Yes.
In the meantime, 2022. Your case is and that there is one to 2009 which has been replaced by 2022.
2000.
Your case is prior to the coming of this 22 Act, isn't it?
No, Lordship.
And after the
During
listen, after the amendment,
Yes, sir.
after the amendment means 22 will be applicable.
Yes, sir.
22, if 22 is applicable, then for house, NOC is not required. RCC building, NOC is not required. That is your case. Now
Yes.
he is saying, if that is there also, but 32 is still there.
Lordship, but he.
So he realizes, see, he may have some wrong interpretations.
Yes.
Correct. As per Mr. Borpuzari, there is no wrong interpretation. I mean, there is nothing wrong in this.
Yes.
As per him, his thing, that your thing is for the plot. Specific, Borpuzari's specific case is that it's for a plot, wherein the RCC building was also standing. Wait, RCC building also standing. Now, he has taken, the officer has taken the interpretation that RCC building is to be sold, then my permission, my permission is not required as per to
He has not said so.
wait, as per 22. But section 32 GMDA is still there. It's a special law, so it will prevail over that 22 Act. So
Yes.
that is why he's saying that that permission is required. That's what he's saying.
Lordship, the deputy commissioner has made 3 observations in the 2 order. The first thing is that the deputy commissioner admitted that his power has been seized to issue the no objection certificate by way of amendment.
In the review order.
In the review order, it is an admitted fact. Already admitted
Correct.
fact.
You are right in that. He said that like to 22, by
And-
22,
yes.
it has been negated.
Yes. Under the same, who satisfied that purpose, he relied the decision of 2022 amendment of the legislation. And again, he, to make alive of his own stand, he relied the amendment which has already passed,
Which one?
2009 amendment.
In
And-
the, no, see, now point is that ultimately there was an initial order. Initial order was being challenged by you.
Yes, sir.
Then you filed a review petition.
Yes,
In your review petition, he passed then final order.
yes.
In his final order, he has given 2 points. 1 point he has said it looks like he has admitted that since 2022 amendment has come, as per 22 Act, that for sale of RCC building, for sale of house, for sale of any other immovable property except land, this permission is not there.
It's not mentioned here.
1 second, just listen. It's not required. But at the same time, he said, yes, that power has been taken away by that Act 2022. But Section 32 is still prevailing. Section 32 is still there under the GMD Act, and 32 being a special act, it will have an overriding effect on the general act. That's what he's saying.
Yes, that is true, Lordship. He referred that, Lordship, his power has been seized under 2022 amendment. Now, he took a stand, Lordship, that by virtue of 2009 amendment, the power of the Metropolitan Authority has the power under Section 32 of the Gauhati Metropolitan Development Act 1985 is still there under the 2009 Amendment of Registration Act. He took 2 different stands. And in the first order, your Lordship may kindly see page number 125, he referred an office memorandum wherein he admitted that to sell such kind of property, occupation certificate is necessary. It is by virtue of 6/12/2022 office memorandum. And office memorandum has come with effect from
Mr. Sharma, leave apart those things.
Yes.
Now you just point me out what is wrong in the order dated. What is that date?
Dated-
17/12/2024.
Now 27 8
17/12/2024. What is the wrong in this order?
7
The review order.
review order. Review order, Lordship, that was filed by the petitioner. He admitted, Lordship, 2, 3 admitted that, Lordship, under paragraph 12, he
Hmm.
admitted that under section 21 of the Registration Act, he referred that, Lordship, prior to subsequent amendment, it was that no testamentary instrument relating to immovable property except for house, flat, residential apartment, commercial building, or any construction or structure erected over on a plot of land shall be accepted for registration.
Okay, we'll have to rise, we'll have to close this today. Or we can put it, we have something to
Yes,
submit.
Lordship. Only my second, that maybe your Lordship may kindly record one thing, that the Learned Council for the Revenue Department has referred that. It may be, Lordship, I am weak to understand the meaning of the language in English language. Lordship, something is he declared that declared invalid, and he declared that sale deed is legally unsustainable. That is, Lordship, I have not understand what
No,
stand he has taken.
no, he's very clear. He's saying that like if the settlement order is based on the sale deed and the sale deed has been procured by certain things which were, I mean, certain qualifications has to be there while giving or registering the sale deed, that was not taken at the point of time.
Therefore, he declared invalid.
That's why he said that like he said that it is irregular. So
Not
an opportunity has
said,
been,
Lordship,
wait.
Yeah.
An opportunity has been given to you that you procure this thing, then your mutation will be fine. But you did not submit that document. That's why your mutation was cancelled. As simple as that.
Yes, Lordship, mean thereby, Lordship, the Deputy Commissioner has declared that the body is enough. But if life has gone, there is nothing.
No.
The life of the registration deed has gone.
No, why
Once
didn't
it
no,
declared,
no, she is still given you opportunity that this says wait for a minute. If you don't listen to what I'm saying is that DC has stated that see this registration has been done.
Yes, sir, Lordship.
Whatever way it has been already done registration, but registration has been done without following the mandatory provisions of law. Now it has been pointed out by someone. Now whether I should keep my eyes shut or not, that is the question. He said that okay, fine, we have done some mistake, but there is an option. You give me this document, then it will be rectified. That is what he said. Then your land will be that document will be in addition to the sale deed, and in addition to the sale deed, that document would have been on record. Then your name would have been mutated in your name. That would not have been cancelled, but you did know, in spite of given the opportunity, you have not done so. That is his argument.
Lordship, only my part of submission, I will reply on that, Lordship. Only today my submission is that whether the Deputy Commissioner has the power to do so. The Learned
So he has referred to two cases.
on that,
No, you just read those cases and come back.
Lordship, only one reply, Lordship. He referred a judgment that is completely decided under the General Clauses Act, and that decision was made and whether the Society Registration Act.
Same, the analogy is same.
But
the analogy is same. Somebody who creates a document,
Yes.
whether he has the power to cancel it or not, that is the analogy.
Lordship, Lordship, this is
Now you have shown a Supreme Court judgment.
Yes.
We are also concerned about this. We'll have to
Yes.
see like how
Yes,
whether Supreme Court Honorable Supreme Court case
Yes.
and like in your case if there are some differences or
Yes.
like that judgment squarely covers the case, that's we'll have to see.
Yes, sir. Apna judgment.
So when do you want it, Mr. Barbujari?
Perhaps, Madam, everything is compared, it will be a never-ending process, Madam.
Yes.
Goes on making submission.
Yeah, let him come back
on
because
my-
the cases that
on
you have
my
referred
judgment.
at least he's trying to build up a case. Let him give some opportunity.
Yes, absolutely.
Uh,
Because Lordship has heard it at length, my lord.
so we'll put it
Can it be on, my lord, coming Tuesday, my lord?
coming
The-
Tuesdays. Coming Tuesday we'll take it up.
Yes, my
Coming
lord.
Tuesday. Heard the party's name is just right. The party's name.
Second of June, my lord.
2nd of June.
Second.
Yes.
My lord, it can be at 2 PM, my lord.
Okay, 2nd of June at 2 p.m.
Yes, sir.
Uh,
Highly obliged.
You come back with those cases Mr. Barbujari has
Yes,
referred
yes.
to and see what
Yes,
is there, what is not
yes.
there, and please be little bit patient. It's good like you keep on arguing, that is fine, but like you understand court's mind also, then it will be little bit easier to you to satisfy this court, right? Okay.
Highly obliged.
So deeply obliged.